Hi, guys. Good to see everybody. So, there might be some familiar topics as we weave through the story of Tyrone Blackburn and the related cases with Fat Joe. Fat Joe initially sued a man by the name of Terrance Dixon and his attorney, Tyrone Blackburn, back in April, alleging defamation and extortion. And last week, filed by Tyrone Blackburn, we have a suit by Terrance Dixon suing Fat Joe and others for civil RICO and a bunch of underlying predicate acts. I did link to a stream that HappilyAngryLawyer did. It's in the description of this video, where he looked at the latest complaint filed by Dixon against Fat Joe. Today, we're going to kind of unravel a little bit about Tyrone Blackburn, how he got into this area of law, some issues he's facing with disciplinary committees in the Southern District of New York, some things that judges have said about him, some other high-profile cases he's been a part of, and we're going to look at the April filing, the initial filing by Fat Joe, filed by Joe Tacopina, another familiar name for you guys, I'm sure. He's the attorney that represented ASAP Rocky and got him that acquittal. It's going to be a lot. We're going to get a top-level summary of everything, and then we're going to get into it's only a 25-page complaint, so it's not going to take that long to get through the complaint itself. But we're going to get to the who's who and how we got here, and there's a lot. So let's jump in with why we're here today. Why are we here today? You can probably guess by the thumbnail of this video, or the title. The attorney, Tyrone Blackburn, was arrested today. He was arrested. He allegedly mowed down Fat Joe and Joe Tacopina, their process server. So let's see what happened. More drama in the Fat Joe civil case. His accuser's attorney, Tyrone Blackburn, and let's clarify here, let's repeat it. In the defamation and extortion case against Dixon, it's also actually against Tyrone Blackburn. Tyrone Blackburn is a named defendant in the lawsuit Fat Joe has against him. So it's not just he's representing someone. No, he's a named defendant. So this guy apparently ran down a process server with his car in New York City. So a rep for the New York Police Department tells us Blackburn was taken into custody Wednesday morning and booked for assault. Cops say it all started on the night of May 12th, when Blackburn got into his vehicle as a 66-year-old messenger was serving him a complaint in the Fat Joe case. Blackburn allegedly slammed his car into reverse and backed up, hitting the process server in the leg and causing a minor injury. The victim reported the incident to the police. Blackburn's arrest stems from a messy legal matter involving Fat Joe and the rapper's powerhouse attorney, Joe Tacopina. So this is a still from ASAP Rocky. Tacopina tells us Blackburn sent a demand letter on behalf of Terrance Dixon to Fat Joe requesting $3 million. Now we're going to see like a pattern of numbers. It always seems like there's a request for about this amount. And then with Blackburn, when it goes to a stage where, a lawsuit's actually filed, his number or the client's numbers seem to be that $20 million ballpark. So, but yeah, they initially requested $3 million for allegedly co-writing music with the hip hop star. We're going to get into that. Tacopina says they blew off the letter, but Blackburn followed up with another demand letter, then claiming Fat Joe was messing around with minors. Tacopina says they wanted to get out ahead of the situation, so they filed a lawsuit alleging defamation and extortion against Blackburn and Dixon. That's when Tacopina hired the messenger to serve the complaint to Blackburn. So we're going to read the complaint that it seems like from this report Tyrone Blackburn might have been trying to avoid service for. Dixon has since filed his own $20 million lawsuit against Fat Joe, accusing him of being a pedophile. We've reached out to Blackburn. So far, no word back. So that is your background context of essentially why I was like, oh my God, we got to do this stream. I wanted to look at the lawsuits, but I didn't really have time. But this happened today, and it's just kind of like, we got to go. We got to go see what Taco's got going against Tyrone Blackburn. Good to see you, Greg. Says, oh yeah, I can't wait for this. Gerald says everyone is getting caught up. It's always something, right? Candace, good to see you. Nicola Maxwell is getting caught up on this. I think you're getting the background context with this article, but we're going to get more from the beginning of the complaint. With a complaint, they always give you the background so you can figure out who and whom. Next level says, wow, he was on Choke Channel last night. Do you mean Tyrone Blackburn? Or Fat Joe? Or maybe Tacopina? Yeah, let me know who you meant by that, but good to see ya. And B says, oh, wow, he was mentioned in the Diddy trial as a shady lawyer. We're going to get to that. I realized that this weekend, and I couldn't believe it, but I'm also not surprised. Good to see you, Factual Lie. Hey to Tiffany. Mr. Meme says Taco Joe is the best. Guys, full disclosure, I do like Joe Tacopina's advocacy for his clients, right? So that might be good context for you guys to know while we're reading through this. Maybe I'm going to favor his arguments a little more than normal, but I do think he's a good advocate for his clients. Purple Paradox, good to see you. Happy Annie's here too. Trakeisha's here, destined to be the whole gang. And Terry says with these lawyers doing this, it will make people not want to go against high profile people and these bad lawyers. And that sucks for the people that have legitimate claims, and their claims are tarnished and tainted by the lawyer that's trying to use them as a vehicle, use them as a means to an end, isn't practicing ethically. It's not good. And then Mr. Big Play Bryce says this guy's a shakedown artist. I remember he tried to shake down T.I. That's another one. Yep. So we're going to look at a few of the high-profile celebrity cases that have had Tyrone Blackburn's name pop up. For Always Forever says, hey, I've been saying Blackburn is trash. He can't even file paperwork on time and never vets his client's claims. He needs to lose his bar card or have his bar card taken. So I think we're going to see some things that back up what For Always Forever for Life is saying here. Okay, next level, thank you, says Tyrone Blackburn was on Choke. So that's something to check out, you guys. And what timing? That's crazy. So it was just like an interview or something, and he's just up there talking. And we're going to see some quotes from him in some of the press statements that Tyrone Blackburn has given to the media. So as we go through that, you can imagine Tyrone Blackburn was probably just up here talking to Choke, and today we get the news that he's arrested for running down a process server. So, and Sleepy, good to see you. Sleepy looks wide awake. What happened to the like button? I don't know. And JC, heck yeah, JC's going to make an appearance in the content we're going to go through. So good to see you. Guys, make sure you're following JC. I feel like so many people know JC over on X, but she's gotten her trial channel going more recently. And we've got to support her. So let me pull up her link. But she's done a ton of great coverage of everything going on with Diddy, Sean Combs. And we want her to start doing videos for those that aren't over on X. So let's give her that push. So there's her link in the chat. And speaking of JC, we also have JT. I love my 2-letter J names. So here we go. We're going to start with a little bit of Joe Tacopina. So what I'm going to put on the screen, this is Joe Tacopina's statement in response to the June 19th filing by Terrance Dixon, filed by Tyrone Blackburn, accusing Fat Joe and others of this civil RICO and all of this sexual activity as predicate acts. So Tacopina said, the lawsuit filed by Tyrone Blackburn and Terrance Dixon is a blatant act of retaliation, a desperate attempt to deflect attention from the civil suit we filed first, which exposed their coordinated scheme to extort Mr. Cartagena, that's Fat Joe, through lies, threats, and manufactured allegations. We didn't just sue a disgruntled former employee trying to revive a false claim from 15 years ago. We sued the lawyer behind it all. Tyrone Blackburn has a well-documented pattern of abusing the courts to harass defendants and generate media attention. 2 separate federal judges have condemned his conduct, one for filing headline-chasing lawsuits full of salacious and baseless claims, and another for making repeated legal misstatements and personal attacks in court filings. He is now the subject of a pending referral to the Southern District, that's New York, Disciplinary Committee. So this is what sent me down the rabbit hole. I was like, let's look for these complaints. There was a little bit more of the statement. Law enforcement is aware of the extortionate demand at the heart of this scheme. The allegations against Mr. Cartagena are complete fabrications, lies intended to damage his reputation and force a settlement through public pressure. Mr. Cartagena will not be intimidated. We have taken legal action to expose this fraudulent campaign and hold everyone involved accountable. So there we go. There we go. Oh, and let's see. We've got next level here with the update says, so on this interview, Tyrone Blackburn was talking about Fat Joe. He also said that he's filing a case against Diddy this week. So that'll be a new one then. I think Tyrone Blackburn represented several civil clients suing Combs. One of them we're going to talk about a little bit more in detail here, someone that testified during the criminal prosecution. And again, JC is the one that, brought the confirmation. I was like, wait, what? And JC's like, yeah, that's the same one. So we're going to get into that a little bit. But yeah, he better hurry up and file that before he's in bigger trouble. Or can he even do it now? I'm assuming he'll get himself bonded out. But what a mess. What a mess. So we're going to get into the first little snippet admonishment I found from a judge in relation to Tyrone Blackburn. And this was Judge Otkin. And, Lil Rod made a big name. That's one of the individuals that Tyrone Blackburn filed a lawsuit against Combs on behalf of. And in this article, if we scroll down, we get some admonishments here. We're going to get Blackburn said he respects the judge's order and opinion. In a statement to USA Today, we view this as a win. Defendants wanted a total dismissal and they failed to get it. Blackburn claimed Combs and Coram do not want me to do discovery because I know where all the bodies are buried and I have a huge shovel. Time to start digging. I mean, I'd be careful saying this if people are accusing you of extortion, but okay. But here we go. Let's get to the admonishment. Here, the judge criticized Blackburn's use of separate legal claims filed against Combs as evidence of his presumed guilt. Though Combs faces an increasingly apocalyptic set of legal challenges, including a federal racketeering and sex trafficking case and a torrent of civil suits, none of that can be used as evidence of his presumed guilt, Otkin warned. So, chat, this is a judge having to admonish an attorney. I'm not a lawyer. We get lawyers in the chat from time to time, but for the most part, you guys in the chat aren't lawyers either. But I would say the majority of you guys know, and maybe you're questioning because why would a lawyer do that? Is that really something you can do? But you guys know you can't just use a allegation against somebody as proof of guilt in another instance. And from this admonishment here, it seems like the judge is scratching his head that he even had to tell an attorney this. So this seems like Tyrone Blackburn filed a bunch of lawsuits because some of these civil suits were filed by Tyrone Blackburn himself. Others weren't. But what kind of racket is this? What kind of system is this? You go and file a bunch of suits against somebody. And then when you're arguing in an individual case, you say, well, there's 5 other suits against the same person. That's evidence of their guilt and liability. That's circular. That's self-serving. So the judge went on. He said that any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. The judge also chided Blackburn for unnecessarily insulting Combs' legal team in his filings and hurling schoolyard taunts. I think that was the end of the article here. But right, imagine a judge needing to tell an attorney this. It should be known. That type of admonishment shouldn't have to be made. And here's where we get JC featured in here. So this weekend, when I was looking backwards at these cases, I was like, this is the moment I had the realization. I was like, wait, Tyrone Blackburn handled Brianna Bongolan, her claims. He represented Brianna Bongolan in, the things that she was claiming she experienced while dealing with Sean Combs. The infamous claim there was the hanging off of the balcony, where Combs hung a friend of Cassie off of a balcony. Well, there were some issues with that, and Nicole Westmoreland led cross-examination on this and kind of had a Perry Mason moment where, the metadata, when you're saying this occurred, you were in Los Angeles, and Combs and Cassie were in New York for the weekend for a show where Diddy was making appearances. So it wasn't just like his device could have been there and he wasn't. And so that was a Perry Mason moment in the trial. And we ended up getting some testimony from Bongalin that, well, my attorney lied. I had to fire him. He was saying things that weren't true. That attorney was Tyrone Blackburn. So when I said this, JC came in here and was like, yep, sure did. She testified on the stand. She fired him due to him putting out the false information in her lawsuit that she did not agree with. So, attorney filing lawsuits with false information that their client doesn't agree to. And maybe the client in one situation is just trying to save their own butt, right? Because that can happen. Your client can make representations to you that are false. But if you're doing your due diligence and trying to vet the claims to the best of your ability, it's not necessarily, it doesn't mean that the lawyer's necessarily unethical. But it's also possible that Brianna Bongalin is telling the truth. Those extra details I didn't provide to him. That's not true. That's not coming from me. And that's very, very problematic for the attorney. And then that same attorney is using these filings. If an attorney is including representations that aren't even coming from a client in filings for a given client, and then going over to another, let's say he goes over to the Little Rod suit and says, well, you know what, Judge Otkin? He's also accused of dangling somebody off a balcony. And he's relying on words and representations that originated with him, that his client didn't tell him and didn't approve of him putting in that filing. And he's circling back to rely on allegations he wrote to substantiate a different civil filing. That's really not good. That is just really not good. So that was just crazy. It's just like, of course, it's like, it's so hard to believe, but it's so easy to believe. Crazy, crazy, crazy. So then the next thing, we're going to get into some more admonishments, but I ended up looking over at Tyrone Blackburn's Instagram. So, and right away, I saw this picture of Joe Tacopina. So I'm like, all right, what's going on here? So he posted this the day of the filing. So April 29th, Tacopina, Fat Joe file their defamation and extortion lawsuit against Terrance Dixon and Tyrone Blackburn. Same day, we get this post from Tyrone. And it's still up right now. And I think it's pinned. All right, this one's not pinned. This one is. He says, and he tags Joe Tacopina's Instagram account, you ran and filed a baseless lawsuit against my client and me in the Southern District of New York, alleging defamation and intentional infliction of emotional distress in an attempt to get ahead of the forthcoming lawsuit against your client, Fat Joe, and tagging him too. No matter how hard you try to deflect and cherry pick emails and conversations, your client has a lot of explaining to do. I invited you and me to meet with the SDNY prosecutors, which this is an attorney dealing with civil matters, deciding on behalf of prosecutors that we're just going to have a meeting when I say we're going to have a meeting. I'm going to extend the invitation on the prosecution's behalf. That's not how it works. That's not how that works. But you have yet to respond. You can bring your baseless accusation of extortion, and I will bring the 19-minute audio recording of your client's felonious henchman, Pistol Pete, soliciting a former member of Terror Squad to lure my client to a specific location for Pistol Pete and his thugs to pound him out. Your client, Fat Joe, ordered a hit job against my client. Pistol Pete also discusses how he had to run down on Tony Yayo, a member of G Unit Brands. And all of this is tagged, guys. So if you're listening, all of these names, tag, 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 which to me signals this person wants exposure. Due to some feud, we're not saying what feud, but some feud with 50 Cent, and run up into clubs to attack other victims. Your client should also prepare to answer questions surrounding 2 additional recordings where 2 females discuss your client's disgusting pattern of grooming and sleeping with 16-year-old children. Now, what's interesting to me is if any of this doesn't match what's in the already filed complaint, we might have a problem where this might not all be protected by litigation privilege, because this is before he filed anything with the court and technically before he was served, because we find out that in May, he's allegedly running over a process server in relation to process service for this case. So there was that, and he still got this up. Still got this up, chat. And I didn't see it right away. I went back, and then there's this pinned post. There's this pinned post, guys. Let's see, is there a way? It's always a little finicky to deal with Instagram. If I zoom in, what happens? All right, well, I'm going to read it too. Sorry, it's hard to read. But the image is a screenshot of an email from Tyrone Blackburn to Joe Tacopina and Chad Siegel. That's Tacopina's law partner that was sitting next to Tacopina during the A$AP Rocky trial. And Jordan Sieve, another partner at, actually, I think it's a different law firm, but Jordan is one of the signatories on the April 29th lawsuit filing. And then Erica Manera. So not exactly sure who Erica is, but I know we get to her name eventually. Good morning, Joe. This was May 1st. I'm following up on my previous email. What day would you like to meet me at SDNY so you can present your case for extortion and I can present my case for RICO and sex trafficking? Now, what's the problem with this? We have an April 29th Instagram post, social media post, something that any attorney, if this was their client running and talking about, the attorney would be like, oh God, why did you run to social media? Why did you run to social media? And then on May 1st, we have this post with the screenshot of the email also saying May 1st at 10:05 a.m. May 1st. I'm following up on my previous email. What day would you like to meet me at SDNY so you can present your case for extortion and I can present my case for RICO and sex trafficking? Now, mind you, these are civil actions at the moment. We did hear Tacopina say law enforcement's aware of the extortion. It seems like after May 12th, they would have had other reasons to be looking for Tyrone Blackburn. But you're now sending this May 1st email when you've already acknowledged awareness of the filing, the April 29th filing, and you're inviting someone to go present to a body that handles criminal matter. Well, I guess SDNY could be civil too. You're trying to present your case for extortion. It's already been presented. It's been filed. So what is this? Like, you don't have the power to set up this type of sit down. You know, it's not like a judge in the Southern District of New York says, you know what, I want you guys to do some mediation, see if you can work it out. No, this was just filed. And the filing was acknowledged in this April 29th post, even though he's going to avoid process service. And he's just extending invitations to invite people to have a sit down and present it for the first time ever. And I'll present mine. This is the wrong way and the wrong time. This is just weird. This is just weird. It doesn't make sense. We can have a conversation with federal prosecutors. So here comes the criminal side of it. And Homeland Security investigators. I plan to fly in from Florida for the start of the Diddy trial, but I'm willing to come today if you want to meet with the Southern District of New York and Homeland Security tomorrow. The latest flight to New York is 8:40 p.m. Let me know. Now, what does this sound like? I'll get there today. I'll go there today. We'll just barge our way in and make the Southern District of New York and federal prosecutors and Homeland Security, we'll just make them sit down with us as soon as I arrive. We'll just make it happen. You have this filing come in where you're named as a defendant on April 29th. And on May 1st, you're like, I'll fly there right now. Please, 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 please. This to me sounds super desperate. I don't even have another way to look at this. And then we have a caption. So this is his May 1st email, and this is his May 1st caption. Again, he's tagging everybody he names. Joe Tacopina Small. I've been emailing you for several days. Now, the email says following up on my previous email, singular. I've been emailing you for several days trying to get an answer for my invitation to meet with Homeland Security and federal prosecutors so you can present your claim for extortion against my client and me, and I can present my claim for RICO and sex trafficking against your client, Fat Joe. Assuming you missed my last 3 emails, I figured I'd try to reach you here. It is mind-boggling that you are willing to tell TMZ that my client and I are attempting to extort Fat Joe, but you're not willing to accept my invitation to meet with federal prosecutors and investigators. One would think that if your client is being extorted, you would seize the opportunity to present the extortion attempts to law enforcement. And we've heard mention that from Tacopina that law enforcement is aware of the extortion attempts. So this just seems like conjecture or an assumption. So where are we at? What's your pulse on this so far, chat? And you don't have to steer in the direction I'm going. I have strong enough feelings here that I'm telling you, I think I'm constrained in how I can view this email. I don't see why anybody in their right mind thinks that they can just invite a potential civil litigant, an opposition party, to go and sit down at the Southern District of New York with federal prosecutors and Homeland Security whenever I can catch a flight. I don't have a way to make sense of that, and maybe it's my lens. Maybe it's the lens I'm viewing this through. I'm fine if you think that. But that's just what I think, you guys. And holy moly. Purple Paradox says, I wonder if Blackburn ever got a payout. So we're going to look a little bit at how he left his position. He was legal counsel for JP Morgan Chase or Morgan Stanley. And he sued for discrimination, and he got a settlement out of that. I don't know the exact terms. I think it was visible. He uploaded the settlement negotiations to the docket without any redactions, and the opposing party was like, court, he knows better. Can you redact that? Can you take that off the docket from public filing or private negotiations? So I didn't really look too far into that to see if there's a copy or more information available. But once he did that, some of the first clients, he used that money. He said he's used that money to start his own private practice. And his first set of clients were other coworkers from where he worked. And we'll look a little bit at those. In one of those cases where he's representing his previous coworkers, he gets an admonishment from the judge again. So he has gotten a payout. He used it to fund his private practice, and that's how he shifted from the corporate world over to this private practice where he's pursuing civil sex assault claims and things of that nature, personal injury. Hey, Creatively Gariel, good to see you. D Peel's here. Here comes drama is here. The drama is here. The drama is here. Kay Schmidt, good to see you. I've seen you in hanging around in other chats. Guys, if I've seen you in a chat for a Karen Read, I've tried to say hi to people, but all of those chats have been so busy where it'll be like, you can't comment for 3 minutes. You can't send a chat every 3 minutes. I know Trikisha was one of them. I was trying to say hey to her in, I don't know what chat it was. Maybe like the lawyer, it was moving and it wouldn't let me send it. And I was like, you know what, forget it. But Kay Schmidt, good to see you over here. Kay Schmidt very generously gifted 5 memberships. So big thank you for supporting the channel. More importantly, glad you're here hanging out, because this is the type of attorney sparring. You guys know I love any moment to use this. I love any moment where I get to bring up something about attorney sparring. So I am glad you're here. Big thank you. Franju P. Diddy says, just stopping by. I love this channel. Love you right back. Oh, please don't ever change your profile picture. Peter Ortiz is in the building. with the green amphibious emojis. He says, "Hello, my fellow slime and cat." Right back at ya. Amy E. Amy E. Please, 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 if there is footage out there of Tyrone Blackburn's arrest, please get it on your archive channel. That would be amazing. If I see it, I'm going to send it to you immediately. But good to see you guys. Amy is so nice. She's always in here showing love. But she's got her own channel where she does a ton of uploads of all things that will keep you entertained. So you guys know the drill. I'm going to drop her link in the chat. And I love that my hotbar auto-populates her channel for me. It's so much easier. So make sure you go and check out Amy E. Let's see. Today you've got, oh gosh, attempted murder suspect's escape plan comes to a dead end. That's the type of stuff, guys. It's like the craziest body cams or trial court moments, weird defendants, weird antics. She's got all of that tea over there. Brooklyn, I've seen you in a lot of Karen Reed chats. Good to see you over here. Yes, please RSVP for the invitation with Homeland Security and bring some sandwiches for the meeting. Like, what are we doing? Like, my flight arrives at this time. If I DoorDash, we can get it all there at 11, right? We can all be there with food waiting to go. Like, just crazy. Just crazy. And Happily Angry Lawyer. Shout out to Happily Angry Lawyer. The F is this headline. What? Oh, are you talking about the arrest? You just heard about the arrest? The arrest. Just crazy, 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 crazy. Like, what are we doing? Oh, okay, so what do I have next after this hot mess Instagram? So, and I mean, we might look at his ex a little bit. He seems to have an ex account where some of it is just like hoo-ha. He's engaging in like stand battles, but then he's also like soliciting clients when there's viral news about something happening. He's like, tell them to call me. I'll connect them with my friends at the feds. So we're going to see more spontaneous invitations. But I didn't really look at much else on Time Tells Truth. There we go. He's got a posting about the T.I. and Tiny situation. The headline he's screenshotting says T.I. and Tiny say they are innocent of these fake claims amid sexual assault lawsuit. For good measure, let's read his caption. He says, Tyrone Blackburn says last night in the Superior Court of the state of California for the County of Los Angeles. Did he copy and paste this? My co-counsel Rodney Diggs and I filed suit against Clifford and Tamika Harris for drugging and raping our client in 2005. We are preparing to file for other survivors in the coming weeks and months. If anyone was sexually assaulted or raped by Clifford and or Tamika Harris in the state of California from 2009 to present day, you still have until December 2026, I know where this is going, to file a civil suit in California. Just like the ASA, the Adult Survivors Act in New York provided a 1-year look-back window, California has established a 3-year look-back window. Look at this. Happy filing with an angel face. That just seems like inappropriate tone. I don't like to tone police. But this is an attorney inviting people to bring claims forth to him under this new look-back window. And he ends it with, just so you know, you can run here, happy filing, angel face. That's a little tacky. We'll say it's tacky. We'll say it's tacky. And this was back in January of 2024. So obviously T.I. and Tiny denied the allegations. Oh my gosh. Not the time to use an emoji. Let me close up some tabs, you guys, and we'll move on to the next bit of tea. Let's see. Okay, so the next bit of tea, we heard Joe Tacopina reference a referral. A judge referred Tyrone Blackburn to the Southern District of New York's Grievance Committee. I'm going to drop this link to the full opinion from the judge. It's quite long. It is pretty long in the chat. Just calling it the opinion. But I'm going to use these little pictures here for the summary. So this was an opinion in order referring Tyrone Blackburn to the Grievance Committee of the Southern District of New York by Judge Denise L. Cote on April 3rd, 2024. Here's the important part. Background. Let's see. Plaintiff filed this legal malpractice action on December 14th, 2023 against defendant attorneys Leanne Fisher and Michael Tobenfield and their law firm Fisher Tobenfield. He did so after being advised by defense counsel that complete diversity of citizenship did not exist. So this isn't the right forum. Because the plaintiff and defendant Fisher are both domiciled in New Jersey. On February 9th, defense counsel requested an immediate conference to discuss adverse counsel's abusive tactics and the lack of subject matter jurisdiction. The footnote says the initial conference was moved at Blackburn's request from February 16th to March 5th. Defense counsel submitted the December 15th email. So she's saying, hey, look, we wrote to Blackburn to let him know that there was an issue here. Here's the email we sent, repeating her representation to him that defendant Fisher is domiciled in New Jersey. In response, Blackburn filed a notice of voluntary dismissal as to defendant Fisher on February 9th and objected to the request for an immediate conference. Blackburn explained that he had voluntarily dismissed the action as to Fisher, even though defense counsel had not produced evidence of Fisher's residence. The dismissal of Fisher did not solve the question regarding jurisdiction, however, since defendant Fisher Tobenfield takes the citizenship of its partners. So this, to me, when I read this, I was like, he pulled out at the last minute before he would get caught and get admonished by a judge. And, if you have these serious claims and you're only using this claim against this party to tie another party, the law firm, into the case, that seems like a bit of funny business. And, judge seems to agree. And it's a bit longer of an order. But let's see. Here we go. Just 11 days after filing the December 3rd, 2023 letter admitting he could not establish diversity in the May Vonderschmidt action, Blackburn filed the complaint in this case. So what's the problem? He's doing the same thing in another matter. Does it remind you of Tony Busby a little bit? As Blackburn has admitted, he failed to comply with his Rule 11 obligation in doing so. Blackburn argues, however, that neither he nor his client gained anything by filing this case in federal instead of state court. The record in this case and the history of his other cases in this district contradict that claim. At the March 5th conference, defense counsel reported that Blackburn had told her he filed this case in federal court because doing so would make the press more likely to pick up on it. So the defense attorney saying, Blackburn told us why he did that. If we go the federal route, media's going to pick it up. And what do we see him doing when he's making these public posts on social media? He's tagging any party that's relevant. It's not just like I'm tagging Joe because I want a response from Joe. He's tagging anything, in my opinion, to get this exposure. And in these matters, it seems like he's relayed to another attorney representing an opposing party, well, I filed it in this venue because the press would be more likely to pick up on it. You have to be so comfortable to even, this is an adverse interaction, right? You're speaking with opposing counsel, and yet that still comes off your chest. You don't just keep that to yourself. You just volunteer it. A reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Blackburn has called defense counsel in this action a disgusting racist for rejecting his preferred mediators. So if you don't work with the mediators I want to work with, it must be because of some type of bigotry, racism, which to me seems like, I'm sure that can happen. But coming from Tyrone Blackburn, I think it'd be reasonable to think he's trying to strong arm, work with the people I know that will lean towards me or be amenable to my mediation requests. In response to this court's order requiring plaintiff to submit an affidavit regarding the representation made by plaintiff to counsel regarding Fisher's residence, Blackburn filed a wholly inappropriate 53-page affidavit containing multiple irrelevant and scandalous accusations against Fisher. Now, you guys know I linked Happily Angry Lawyer went through the filing, the June 19th filing against Fat Joe filed by Tyrone Blackburn. I think this matches some of the criticism that I personally have, and I garnered that Happily Angry Lawyer, as he went through that, seemed to get to. Just a whole bunch of talk, slinging scandalous accusations against irrelevant parties, or not naming the party that we're accusing of scandalous behavior, right? Just a mess of scandal. Regardless of Blackburn's intentions, his actions in this and prior cases, again, the pattern, indicate a repeated failure to meet his Rule 11 obligations. And then they cite here Story v. Cello Holdings. The standard for triggering the award of fees, so request for sanctions under Rule 11, is objective unreasonableness and is not based on the subjective beliefs of the person making the statement. Significant resources have been spent by judges of the court and defendants named in actions he has filed to address glaring deficiencies in his filings. Glaring deficiencies. A referral to this court's grievance committee is warranted. So here's how we get the referral to SDNY. So conclusion, Tyrone A. Blackburn is referred to the grievance committee of this district for such action as it deems appropriate. This was back on April 3rd, 2024, and this is Judge Denise Cope. So what do you guys think of that? Good to see you, G. Or D, sorry. The Great Britain flag says GB. I just minced all the words it shows on my screen over here. But hello, D. Just crazy, crazy, crazy. Yeah, and this is the thing, right? So Purple Paradox says Blackburn must have gotten someone or two people to settle out of court, and he keeps throwing anything at the wall, hoping someone will pay. And I think that is a problem, and not limited to this type of scenario of, hey, we're going to send a demand letter and hope you pay for it, and if you don't, oh well, we'll just keep trying. But there's a lot of situations in everyday life, even people that aren't rich or high-profile celebrities that have a bigger target on their back for people trying to get money from them. But just when things are enabled, when bad behavior is enabled, why would somebody be deterred from trying it again? So, just crazy. Crazy. Oh, oh, Peter Ortiz is saying hi to for always, forever, for life. I thought you were saying high four as like one finger short of a high five. But I get it now. That's why I was staring at the screen. I was trying to work this one out. One finger short of high five is a new one. I never have heard that sentence before. Just crazy. And then Trikisha, thank you for being a member for 10 months. Says happy to celebrate another month with the cat and the cat chat. Love that. So glad you're here. And then I think I have one more. Yeah, I have one more judge admonishment. I'll drop the full filing in the chat. Again, these are all over on X. I was up to like 4 or 5 in the morning looking through these different cases and trying to download them. And then I started going through them and just made a thread. Once I woke up and started going through them, I was just posting random stuff as I went. So if you want to take a look at that, that's over on X. This is the filing we're going to look at here on the screen. We're just going to look at the relevant parts. Let's see. This is a different judge, by the way. Here, nothing in the complaint establishes anything more than a possible motive by Morgan Stanley to carry out the alleged cyber attacks. So honestly, guys, if you want to do some reading, I think this entire order is worth reading. It's just too long to read on this stream. But after we get through all the allegations, the judge is just sitting here going, nothing in the complaint establishes anything more than a possible motive by Morgan Stanley. The defendant, Tyrone Blackburn, is, filing on behalf of his clients these claims against, to carry out the alleged cyber attacks. At best, statements that Morgan Stanley had the capacity to monitor and to remote into its own firm-issue devices. Nor does the complaint at any point allege that defendants, Hornbach or McCool, were actually involved in any of this. With respect to plaintiffs' vague and conclusory allegations that the cyber attacks were carried out by agents of Morgan Stanley to mitigate the liability presented by evidence of misconduct. That's plainly. Now, if you're not looking at the screen, I'm not saying that twice. This judge said that's plainly insufficient. They said it twice to state a claim as to defendants McCool or Hornbach. Instead, the complaint describes. I went to a different part of the suit. Let me open this so we can make it bigger. In a different part of the order, the judge says, this is the exact type of speculative inference that was grounds for dismissal in the cases I've just mentioned. So they were citing case law that gives the judge permission to follow the same example. And it's the precise issue I noted to the parties in the pre-motion conference when I warned plaintiffs, Tyrone Blackburn and his clients, of the insufficiency of mere temporal proximity as a means of establishing causation. So as a judge, I already warned you that this wasn't going to be the right way to do this. This was going to be an insufficient cause of action. You can't establish a causal relationship just by saying somebody existed at the time a thing happened. The portions of the amended complaint that actually describe the computer interferences, Mr. Ngo alleges, and this would include paragraph 160, 170, 167 to 171, 173, and 175. So this is citing specific portions of the complaint as written by Tyrone Blackburn. The one exception is in paragraph 175, which states that defendant Morgan Stanley at one point referred to the correspondence.zip folder by that name, and even in that paragraph, the inference is then attributed to unnamed external parties. We're not even tying the people we're filing the complaint against to the things we're alleging, the actions that we're alleging happened. Elsewhere, the attacks are attributed to similarly unnamed malicious actors and not to any of the specific defendants. In fact, it's never explained how Morgan Stanley knew of Mr. Ngo's existence or how they would have been aware that at some point she had downloaded the correspondence.zip folder to her personal device after Mr. Vonderschmidt sent it to her. In the portion of the amended complaint that specifically outlines the CFAA claim, Ms. Ngo states in conclusory fashion, and when they're using the plaintiff's name, again, it's Tyrone Blackburn that's writing this document. They're just using the plaintiff's name to say that's the party on the filing. That defendants accessed her computer and server, and that the defendants did not have authorization or permission to do so. But then broadly refers the reader back to the factual background in order to fill the gaps. So this judge was not happy. This judge was not happy. This was a very entertaining read. It was quite long, but I definitely recommend checking that out. Oh, and I think I linked the wrong one in the chat. Let me get the correct link. Actual link. But yeah, you'll see it's 75 pages. Oh, this complaint is 75 pages. But if you want to check it out, and again, he always does this thing where he inserts people's headshots, and I like to know the who's who. But it is kind of like more of a salacious thing. It's kind of like drawing attention to the person you're accusing, making it easier to subject them to public scrutiny based on what you're alleging against them in a filing, right? Not something that's been proven in a court. Just put the faces and names all the way out there for the maximum damage. So similar format in really any filing I think I've looked at. It was Lil Rod's lawsuit had the same thing. I think he did the same thing with the DJ Academics lawsuit with Miss Abashi was his client. Maybe still is. So yeah, judges don't seem to love the way the way Blackburn files things. We've got one more top level story, and then we're going to get to the Joe Tacopina complaint. So I saw Nicki Minaj's name come up and saw a lot of mentions about this in Tyrone Blackburn's replies to people on Twitter. And I was reading about it, and apparently Tyrone Blackburn tried to bring gang allegations in and claimed that Nicki Minaj was a gang member. So one of Tyrone Blackburn's clients is Jennifer Huff, who, she has, her ongoing situation with Nicki Minaj's husband, Kenneth Petty. And at some point, Tyrone Blackburn brought a harassment suit that also named Nicki Minaj. And she's since been dropped from that lawsuit. But this was back during around that time frame. And this headline says Nicki Minaj and Kenneth Petty affiliated with New York gang, lawyer claims. And this is what was said. Quote, Kenneth Petty and Mirage were both in this district in Jamaica, Queens, New York. As seen on an Instagram live video currently up on Mirage's Instagram page, both Mirage and Petty were seen associating with members of the Mac Ballers set of the Bloods gang. Petty and Mirage are both members of this gang, Tyrone Blackburn told the judge. How did we get there? They were seen associating with members, and then they're members. Connecting his allegation to the lawsuit, Blackburn explained that members of this gang have harassed Huff online. He said, shortly after Petty and Mirage are spotted with their gangster colleagues, a member of the gang posted a death threat to Miss Huff on Twitter, stating, Jennifer, if you see this, the Macs are coming to get you. And this might sound scary, but there wasn't an indication to me that we get an identification of the person he's just asserting to be a member of the Mac Ballers set of the Bloods gang. And we just saw more than one judge say, your filings are vague. Your filings don't connect people to actions. You're just vaguely citing malicious actors and not naming the parties you're alleging did XYZ. So if I apply that same pattern of behavior, that's the lens I'm interpreting these claims from Tyrone Blackburn. So, and that there just reminded me a little bit of our gang experts and that whole saga with YSL. Oh, I've got one more. So I saw this came up and I just like this quote. So this was Fazaya Abashi versus DJ Academics. Tyrone Blackburn wrote the complaint for Abashi, but there was a statement that Tyrone Blackburn gave to XXL magazine. Litigation is always the last resort. After several unsuccessful attempts to resolve this case privately, Miss Abashi was left with no choice but to file Mr. Allen, that's Academics, hubris will be his downfall. And I'm not here to weigh in on the substantive claims in this matter, but I thought it was very interesting. He goes to XXL magazine and he's like, litigation's always the last resort. We don't actually want to litigate. We'll keep attempting to solve this privately. Request a couple million here and there. And Chad, I think you know what I'm getting at. So I think we've gotten through everything top level. I'm pretty sure this is his Twitter. It's so unbelievable that I'd rather it not be, but I'm pretty sure that it is. Maybe it's not. But I said earlier in the chat that he's like soliciting clients when there's viral stories and then extending these invitations again. So here, somebody named Screwface Jean says, Meek Mill responded to my tweet exposing Academics. And Tyrone Blackburn, this is January 6th of this year, says, give the kid's guardian my info. I'm assuming this is where Academics was speaking with weird language about a young kid on a stream. And I saw people calling it out that it was inappropriate language. So I think this was around that time. But Tyrone Blackburn says, give the kid's guardian my info. I will make an intro to the feds. Prosecutors in New York and New Jersey would eat this up. I have his address. Homeland Security as well. DJ Acadiddy. Now, so I don't know if this person claims a relationship to the kid that was it was like some kid that's also a growing streamer. So are you just telling this random person And I'm not really trying to call this person random, but you're just on here on X saying, you, Screwface Gene, give the kid's guardian my info. I'll make an introduction to the feds. Homeland Security would love this. What? So there's a lot on this X account, you guys. And again, I'm telling you, it's so unbelievable that I would rather it not actually be him. But going back through it, I mean, it follows all the cases that Tyrone Blackburn's been involved with. Tiffany Haddish, Nicki Minaj, um, just a bunch of stuff. Actual footage of me in a courtroom and it's a GIF or GIF. Like, I don't know. You guys could take a look through this profile and see what you think. But that January post was before the Joe Tacopina thing and what we see on Instagram. So it seems like pretty consistent language and invitations. That's why I think this is actually him. So, you know, here's Tyrone's Twitter or X or whatever, or whoever seems very similar to Tyrone's X account. So there's that. And now the filing. If you want to look at this filing or the June 19th filing filed by Terrance Dixon, kind of in response, but a separate action, they're both linked in the description. Again, Happily Angry Lawyer went over the June 16th. We're going to go back to April 29th and see the initial lawsuit. So this was Fat Joe, Joseph Cartagena, filing against Terrance Dixon, Tyrone Blackburn, and Tyrone Blackburn's law firm. And I don't know, I feel like there was a little bit of talk about this, but when the big news broke last week about the sexual assault claims and minors and all of that stuff against Fat Joe, and nobody was really bringing this up. So I'm assuming it went under the radar more than I thought. So that's why I think it's worth. We're going to take a look at it. But if you want to see the filing from Terrance Dixon and Tyrone Blackburn, Happily Angry Lawyer is your guide there. We're going to make this bigger because this is going to be a lot of reading. I see. Shout out to Chloe Albert's Revenge. I see a little Mike and Quez reference. Maybe when we round this stream out, we'll do the Michael Sprinkle song. That'll be our outro song today. So, wait, for real? Did you go to high school with Onika Mirage at the time, now known as Nicki Minaj? Ooh, she's got AKAs. Definitely part of an enterprise. Oh my goodness. It's good to see you. You know, anytime Chloe's in the chat, you can go from reference to reference like this, and it's just like super fast. Sassy Experience, good to see you. And yeah, he's no longer fat, just call him Joe. Guys, we've got to stick with the Fat Joe name here because we have Joe Tacopina, and I don't want to get the two confused. So, Fat Joe, who's now no longer fat, also known as Joseph Cartagena, and Tacopina uses Happily Angry Lawyer, should attest to this. In this filing, guys, we're going to use parties' last names to refer to who we're speaking about. But if you go over to the related case and you look at the way that's written, sometimes you'll have defendant singular used to discuss more than one person, and it's not clear who. We're going to jump back and forth between first name, AKAs, last name, all of them, repeating the AKAs throughout the document. It's just, you know, a formality issue there. We can't make up our minds. But here, it's important to know that if I say Joe, probably talking about Joe Tacopina, I'll try to say Joe Tacopina when I'm making commentary about the attorneys. And Cartagena is Fat Joe Cartagena. So, and he's going to make this a demand for jury trial if we take it that far. So we've got Joe Tacopina, we've got Chad Siegel. You guys remember both of them from the ASAP Rocky trial. They do other cases together. And then we've got Jordan Sieve from Reed Smith. This is a different law firm here, but he's here. He's an attorney of record. So, plaintiff Joseph Cartagena. as and for his complaint against defendants Terrance Dixon, Tyrone Blackburn, and the Blackburn law firm, hereby alleges as follows. Plaintiff Joseph Cartagena, who is professionally known as Fat Joe, is a world-renowned musician, entrepreneur, and philanthropist. For approximately a dozen years, and ending nearly 6 years ago, defendant Terrance Dixon, who is professionally known as TA, worked with Cartagena as a hype man, a supporting performer who increases audience engagement with interjections and chants. Cartagena compensated Dixon handsomely for his role, and Dixon never complained or expressed any dissatisfaction with his pay or other conditions of his work. Nor could he. So there's a little punch there. There's a little one of these, you guys. We've got these indicators from the Megan Jackson trial. We'll bring them up when something's a little spicy one-liner. Cartagena began working with Dixon in approximately 2006. Dixon eagerly accepted the once-in-a-lifetime opportunity to be a part of Cartagena's team. He also accepted the generous compensation. All these words, guys, very, very intentional language. The generous compensation Cartagena paid, past tense, done, completed. And throughout their relationship, Dixon enjoyed the perquisites? I didn't know that was a word. Of touring, luxurious travel, and other fringe benefits of being part of a world-renowned musicians team. The relationship ended amicably in 2019, and Dixon never raised any issues or sought any additional compensation over these past 6 years. Yes, 2019 was 6 years ago. Then something changed. In an obvious money grab, all these years later, Dixon claims that he should have been paid more. He claims, parentheses falsely, that Cartagena recently blocked him from getting outside funding for a record label, which was the last straw, quote, that caused him to dredge up decades-old supposed grievances and issues, none of which were aired contemporaneously, and more importantly, none of which are true. Thus, instead of speaking to Cartagena about his post hoc grievances, Dixon made countless posts on social media containing a torrent of wholly fabricated, grotesque, and scandalous allegations, accusing Cartagena of unspeakable acts such as pedophilia, statutory rape, and sexual assault. For example, Dixon published shocking falsehoods on Instagram, including that Cartagena, this is a quote, and it's all caps, was dating and having sex with a 16-year-old girl. B, flew an, quote, underage, end quote, girl, quote, across state lines and out the country. C, we got capital letters again, had a full-fledged relationship with Nikki, who was underage. And D, does Market America know they have a pedophile as they spokesperson? Question mark. So I don't know if we're adding in the question mark, but okay. Maybe this was an emoji. Maybe this was a question mark emoji. Dixon knew that his aberrant statements about Cartagena were false when he made them. And this is an element, right? So we've seen more than one judge say, you know what, Tacopina? I mean, you know what, Tyrone Blackburn? You're not like tying the defendants that you're naming to the actions that you're claiming defendant must have done. You're just naming random malicious actors. Here we already see a huge difference, right? Tacopina, Chad Siegel, Steve, they're all this element here. The knowledge that the statements were false at the time they were made. Right? Because it's not necessarily defamation if you have a reasonable belief in what you're saying. Nope, you got to say it here. He knew they were false when he made them. He nonetheless wielded those statements as weapons in a calculated campaign to shatter Cartagena's reputation and extort him into surrendering to Dixon's outrageous financial demands. Dixon calculated incorrectly. Cartagena is steadfast and resolute. The allegations are false, and Cartagena will never, this is bold and italics, succumb to Dixon's repugnant tactics. But Dixon was not done. Frustrated by Cartagena's fortitude, Dixon hired defendant Tyrone Blackburn, who, in the words of the Honorable Judge Denise Coate of this court, and this is kind of the beautiful thing, right? Because I believe Fat Joe still resides in New York. You have this opportunity to file this in a venue where the judges, even if it's not Judge Denise Coate, there's already awareness within this district of these other matters. And now you're naming this party. Like, it's just, the judges are already going to be aware here. They're already going to be aware. Good to see Aaron. Aaron says, I know what AKA means. Co-conspirator. That's right. That's right. Oh my gosh, a hot mess. Who, in the words of the Honorable Judge Denise Coate of this court, quote, improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Sounds a little bit like the statement, Tyrone Blackburn to XXL, litigation is always the last resort. Litigation is always the last resort. And this was the Fisher case that we looked at. And they attached it here as Exhibit A. And just a few months ago, the Honorable J. Paul Otkin of this court issued a warning to Blackburn because his, quote, filings are replete with inaccurate statements of law and, quote, full of similar irrelevant insults, misstatements, and exaggerations. And that was the Lil Rod case. We looked a little bit at that. Judge Otkin was flabbergasted by Blackburn's misconduct and stated, quote, that any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. Dixon, and you know what? Should we incorporate that as a little bit of spice incorporated through the words of the judge? There we go. Dixon and Blackburn started with a written demand on March 23rd, 2025 for compensation as a, quote, ghostwriter and uncredited vocalist on certain of Cartagena's songs. When this absurd and false claim did not garner the response that the defendants desired, namely an unwarranted payout from Cartagena, they sunk to much lower depths. By letter dated April 21st, so we're jumping from March 23rd to the 21st of April, which attached an intended complaint against Cartagena, Dixon, and Blackburn, threatened to file that complaint not just for unpaid wages and other compensation, but also, and with other disregard for truth or decency, false and outrageous allegations against Cartagena that have absolutely nothing to do with Dixon's purported unpaid wages, including unspeakable acts such as statutory rape, forced labor, sex trafficking, and fraud. To the contrary, Dixon and Blackburn's allegations concern third parties that Blackburn admitted are not his clients. HappilyAngryLawyer covered all of this. It was a great time. These monstrous accusations notably lacking from the March 2025 demand letter. Oops. Are conjured from thin air and once again designed to extort Cartagena to pay Dixon's and Blackburn's outrageous financial demands. Blackburn also made false statements during calls with Cartagena's counsel that he personally verified all allegations and had spoken with critical witnesses, including one of the alleged minors, who have denied speaking to Blackburn. So this is a big uh-oh. This is a big uh-oh. And when this came out, honestly, I think in April, some of the reactions to this weren't so much that it involved Fat Joe, but were people that had been watching Tyrone Blackburn because of another case he was a part of, or cases. And this is the talking point, right? He wasn't vetting his clients. So this didn't really get that big to be big of news until last week when we have this huge salacious filing against Fat Joe. But there was a bit of, there's another person saying Blackburn's not doing the stuff he's supposed to do as an attorney. Blackburn continued to threaten Cartagena on a daily basis with many evenings and late night / early morning email messages to his counsel, stating things like, quote, we will report him to Homeland Security, end quote. That was an 8:57 p.m. email on April 22nd, 2025. Oh my gosh. Now, this is a bit different. This is a bit different, guys. You know, he's sending this before they file this lawsuit. Fat Joe files this lawsuit. But after it's filed, Tyrone Blackburn's over on Instagram. You know, you ran and filed this baseless lawsuit. But no matter how hard you try to deflect, cherry-picked emails and conversations, you said you sent 3. You said you sent 3 emails. So how do you cherry-pick 3 total emails? And here you're saying I invited you and me to meet with the prosecutors. And when you bring in this email that you sent after it was filed, this May 1st email, after Tacopina and Fat Joe filed against you, it's saying, I'm following up on my previous email. What day would you like to meet? I've been emailing you for several days trying to get an answer for my invitation to meet. So you can present and I can present. We can meet there. Last 3 emails. And then we have quotes in this filing. We will report him to Homeland Security. That doesn't seem like an invitation. That doesn't seem like we're going to do the DoorDash. I'm going to fly in at this time. We're all going to get together and have a picnic with, prosecutors, Homeland Security, the whole shebang. We're going to have a whole thing going. This sounds different. This sounds different. Then he says, quote, playtime is over. This is a 12:15 a.m. email. Oh, so this is midnight on April 29th. So was this already? What? Hold on. When did this filing actually go through? So we're on page 4, guys. Ah, there's no timestamp up here. There's no time signature. So at midnight, Tyrone Blackburn is emailing, playtime is over, on the 29th. And then also, on April 28th, we're jumping backwards. The case is just expanded into a civil RICO case. So that was 7:27 p.m., April 28th. And that he was adding Cartagena's marketing partner to the complaint for aiding and abetting, a 9:52 email on April 26th. The threats, however, have failed to achieve their goal. Oh my goodness. Dixon's and Blackburn's conduct is thus a cold-blooded attempt to extort exorbitant sums from Cartagena by leveraging the specter of public disgrace and professional ruin. His defamatory statements accusing Cartagena of heinous crimes are devoid of any factual foundation, relying instead on the power of shock, scandal, and Cartagena's high-profile status to maximize leverage. And Blackburn's thrust to publish false allegations against Cartagena under the cloak of the judicial system are shakedown tactics masquerading as lawyering. And you know what? We're going to highlight that. And are entirely consistent with Judge... Never mind, he got to it. I was going to say we're going to highlight masquerading as lawyering, because I was going to, as soon as we read the sentence, I was going to say, and we've already got more than one judge in this district sharing this opinion in different words, right? But they've expressed things that are consistent with this type of description about Tyrone Blackburn. And there you go. We've got Tacopina and Siegel. Yeah. His tactics masquerade as lawyering, and it's consistent, entirely consistent with Judge Coates' statement above. So we got there. AV, wait, hold on. Good to see you, AV. Did you not see the news about Tyrone Blackburn getting arrested? This is why we're here this is why we're gathered here today, folks. Lawyer suing Fat Joe, arrested for allegedly mowing down Joe's process server. So in May, in New York City, Tyrone Blackburn allegedly runs over, backs up his car into a process server that was trying to serve him with the complaint from this case that Fat Joe filed against Terrance Dixon and Tyrone Blackburn. This is why we're here. So it's so good to see you. But yeah, if that's what you're saying, oh my God, this title, this is why we're here today. And we're looking back at this April 29th filing. It's just ridiculous. And it's like, the more that comes about, the worse it looks. And right above, Peach Pie says, is Blackburn a real licensed attorney in good standing? He's real. He's a licensed attorney. Is currently, he's been referred to a disciplinary committee in the Southern District of New York. So, I mean, we'll see how that goes. And I don't know, with the Diddy case, you guys, we talked about Brianna Bongalin. She's the one that, the incident where Diddy was supposedly dangling Cassie's friend over a balcony. And we have this Perry Mason moment where your metadata shows that you were in Los Angeles and claiming that's where it happened, but metadata for Diddy and Cassie both shows that they were in New York for that weekend. They physically were not present for this thing you're alleging that Diddy did. And that witness, Brianna Bongalin, said, my attorney put that in there. My attorney, Tyrone Blackburn, put that in there. I had to fire him for false statements that I did not want him to put in the lawsuit. So, or in the statement. So I don't know how much longer he's going to be in good standing. And big thank you, Factual Lie, guys. Factual Lie just dropped the channel to follow AV. AV has done a ton of coverage of the Karen Reed case. And I just saw you had Andrea Burkhart and Melanie Little. That was a great, great interview. And I don't remember when you did the Turtle Boy interview, but it was before this week. It was like a month ago at this point that I think you did the Turtle Boy interview. And that was a really great look about journalism and, you know, the implications. What happens if somebody isn't paying attention to something, isn't doing the work to dig things up, and things just go under the radar? And I would highly advise, she's got a ton of Karen Reed content, but if you go back and look for her interview with Turtle Boy, it's different than just the, here's more about the evidence and here's our reactions to the verdict. It's a really great look at journalism, new media, and the difference it can make when eyes are on a matter and the work that people do to bring attention to really cases of injustice. So AV, good to see you, says, hello, you can't make this up. Have a great stream, Cat. Big thank you to you. Love that you always use the glasses emoji. It fits, it fits. But yeah, that's why we're here. this guy, Tyrone Blackburn, he's taking my radar off of Tony Busby for a little bit. Just a little bit. Yeah, and Happily Angry Lawyer says, define good standing. Holy moly. Let's see. Dixon's and Blackburn's conduct is thus a cold-blooded attempt to extort exorbitant sums from Cartagena by leveraging the specter of public disgrace and professional ruin. His defamatory statements accusing Cartagena of heinous crimes are devoid of any factual foundation, relying instead on the power of shock, scandal, and Cartagena's high-profile status to maximize leverage. And Blackburn's threats to publish false allegations against Cartagena under the cloak of the judicial system are shakedown tactics masquerading as lawyering, and are entirely consistent with Judge Coates' statement above. Sorry, why am I rereading this whole thing? Sorry. Cartagena thus brings this lawsuit in the pursuit of justice and to shut down Dixon's and Blackburn's predatory plot built entirely on lies to destroy Cartagena's reputation and business for profit. So we're going to get into the parties, and luckily they're not going to switch names, I don't believe, throughout this complaint. So we'll be able to keep it straight. Plaintiff Joseph Cartagena, known as Fat Joe. Oh, state of Florida. There we go. Defendant Terrance Dixon, professionally known as TA, is a citizen and resident of the state of New York. Defendant Tyrone Blackburn is an attorney and resident of the state of New York. He is the principal of his eponymous law firm, Defendant T.A. Blackburn Law. Blackburn's conduct described in this complaint were taken on behalf of himself, individually, and on behalf of defendant, the law firm. The law firm, Blackburn Law, is a law firm organized under the laws of the state of New York and operates its principal place of business from Brooklyn, New York. Not to be confused with the Honorable Brooklyn in our chat. This court has subject matter jurisdiction. And remember, we read earlier that that Tyrone Blackburn has issues or intentionally disregards what's required for subject matter jurisdiction. All right, he got an admonishment from a judge. We looked at that earlier in this stream. But here, this court has subject matter jurisdiction because the matter in controversy exceeds the sum or value of $75,000. So they're going to ask for more than $75,000 in damages, exclusive of interest and costs, and is between the citizens of different states. That's why we're going federal. Cartagena is a citizen of Florida. Dixon, Blackburn, and the law firm are citizens of the state of New York. Upon information and belief, no member of Blackburn Law resides in or is a citizen of the state of Florida. This court, and I would say, just from what I've caught of, there's always a million cases being filed in the Southern District of New York. So I've heard more scenarios in that area. But when I see stuff filed in Florida, I feel like it's not as friendly of a venue for claims like this. So it happens to be a situation. I don't think they have to venue shop here, but it seems like it's probably the better choice to file in this district, especially since these judges already seem to be aware of the shortcomings of Tyrone Blackburn. This court has personal jurisdiction over Dixon, Blackburn, and Blackburn law because they're citizens of and reside in the state of New York. Venue in this district is appropriate because Dixon resides in this judicial district and a substantial part of the events or omissions giving rise to the claim herein occurred in this judicial district. So factual background. And I think we're going to get a factual background as it should be laid out. So, Cartagena is a native of the Bronx, New York. This is Fat Joe. His music career began in the early 1990s and has spanned decades. He is known as one of the most influential figures in the rap industry. Cartagena has released 11 studio albums and 5 collaborative albums to much critical acclaim. He's sold over 1.5 million albums. He's won Billboard Latin Music Awards, Latin Dance Club Play Track of the Year. That's a mouthful. And has been nominated for 5 Grammys. Cartagena is also a successful entrepreneur. He co-founded the clothing store FJ560, launched his own sneaker line, FJ560, and invested in Rewind It 10 and Up NYC. Cartagena also has countless endorsement deals, which rely on his pristine image. Cartagena is a philanthropist. His many philanthropic endeavors include, in January 2022, helping to organize a day-long fundraiser for families who were impacted by a tragic apartment fire at the Twin Parks Northwest Apartments in the Bronx. In late September 2023, Cartagena visited the Eagle Academy for Young Men in the Bronx and gifted unknowing students over $100,000 in brand new clothing to start the school year. Cartagena frequently arranges speaking engagements at public schools and with politicians to promote a wide array of community-forward initiatives, including educational advancement in low-income areas and public health awareness. Cartagena has received numerous civic awards, including the Key to New York City, and an honorary doctorate from Lehman College. He has a place on the Bronx Wall of Fame. Cartagena's biography with the Bronx Walk of Fame states that his contributions to the genre, his entrepreneurial pursuits, and his dedication to philanthropy have made him a respected figure in both the music industry and the wider community. This is kind of like background, but it would also kind of go, if you're doing all this philanthropical work, it's not just like you weren't paying somebody because you didn't have the money. I think like a little bit of an edge here is, suddenly Terrance Dixon's claiming after they stopped working together in 2019, he's now claiming in 2025 that there's monies owed. Well, Fat Joe has no problem giving money to people that didn't even work for him. So, after years of working together, Dixon fabricates claims that Cartagena engaged in unspeakable acts, including pedophilia and rape. At various times from approximately 2006 to 2019, Dixon acted as a, quote, hype man for Cartagena, assisting him on tours and concerts. In exchange for these services, Cartagena compensated Dixon handsomely. For years, their arrangement worked well and without issue. Some 4 years later, however, Dixon, in a blatant money grab, began to attack Cartagena in order to attempt to monetize Cartagena's fame and good reputation for his benefit. In 2023, Dixon initiated a campaign of public harassment against Cartagena by making and publishing countless defamatory and false statements on his public social media accounts, including his Instagram account @thatstrategy. This pattern of conduct is unfortunately par for the course for Dixon. He has repeatedly told even members of his family that if they did not stop working with Cartagena, he would put false information about Cartagena out on social media and would take all of Joe's money. Presumably Fat Joe's, not Tacopina's. So we get A. Dixon falsely accuses Cartagena of sexual assault. In June 2010, Cartagena performed in Wisconsin. Following a show, a fan made allegations of, quote, inappropriate touching. Within hours, Cartagena was cleared of any wrongdoing. As explained by his attorney, Fat Joe had no contact with and never spoke to his accuser. He was questioned for a few minutes at his hotel room and was never detained by the police. For his part, Dixon never complained to Cartagena, or upon information and belief to anyone else, about the supposedly horrific acts that he witnessed. In fact, the, quote, inappropriate touching allegations was What? The allegation was made against Dixon, not Cartagena. What? Nevertheless, and knowing that his statements were false, on June 17th, 2023, Dixon posted a screenshot of a 2010 CNN News article on his Instagram account entitled, "Rapper Fat Joe Questioned About Sexual Assault Complaint in Wisconsin." So, yeah, that title doesn't say, and this is why titles can be crazy, right? Because a reader might think Fat Joe's the one named, questioned about a sexual assault complaint, probably Fat Joe being accused. Maybe that wasn't the case. Dixon's post featured a picture of Cartagena with the following caption: "At Fat Joe, this rape charge was on you. I know the story and I will go into full detail. Exhibit C." Let's go take a look at that. Let's go look at the post and see what the headline looks like. Oh, you know what? I'll have to download them and we'll look at them. I did download one that we're going to look at for sure. But we'll look at them at the end. We can grab everything. Dixon again accused Cartagena of rape later that day, posting. So can you imagine? Like, this is from 2010, and apparently Dixon might have been the one the complaint was lodged against. But years later, Dixon's just posting a screenshot of an article about it with a headline that one could assume and read the wrong way. And he's posting twice about it suddenly. It's a little weird. It's a little weird. Should I go into detail? 3 question marks. In October 2023, Dixon sent a series of extortionate WhatsApp messages to Cartagena's manager. Dixon sent manager a fake picture of a news headline. So it's not even real. He made up a fake news headline. This is, quote, "Fat Joe statutory rape victim revealed." Dixon threatened, "This is what the newspaper is going to look like. Wow, his daughter is going to be real proud of him. I'm going to tag Jordan, Nike, CNN, the white, the president and the vice president. Every major outlet will have this now. Think about it, just one." That was all one sentence. Oh my God. On the same day, Dixon ominously warned, "The countdown is on. Tell the fat man be smart. I warned him before. And that Joe got it fucked up. I get it. Joe didn't get it yet. I'm the predator. Joe's the prey." I mean, this is kind of weird to be saying when it may have been you that was accused of predatory behavior at a concert a decade and a half ago. But okay, you can go ahead and proudly proclaim you are the predator. Dixon doubled down on his false allegations of sexual assault in a December 2024 YouTube interview, in which he accused Cartagena of sexually assaulting a woman in Wisconsin by placing his hand up her skirt. Dixon knew that these statements were false. Cartagena never sexually assaulted anyone. Authorities never charged or detained Cartagena in connection with the allegations in Wisconsin and cleared him of any involvement shortly after speaking with him. Rather, Dixon attempted to resurrect a decade-plus old false allegation and headline to support his campaign of harassment and extortion. Dixon outrageously accuses Cartagena of statutory rape. Dixon's statements escalated later in 2023. Desperate to harm Cartagena, Dixon accused him of being a pedophile. These allegations were again false, which Dixon knew when he made them. On August 31st, 2023, for example, Dixon posted about Cartagena, whom Dixon occasionally calls Lil Joey, stating, quote, "Lil Joey doing his pedophile dance when he bags another 16-year-old. And I think he included these in his own filing. Or maybe they're in this one. Because I remember seeing it was like one of those like animated filter videos where you can put a head on another cartoon body. Similarly, on September 9th, 2023, Dixon posted another picture and stated, "Lil Joey Cap doing his," is that supposed to be correct? "Doing his pedophile dance. He's diving looking for little girls, 100 emoji." On September 13th, 2023, Dixon posted, these are all caps, guys. Fat Joe, you asked me, do I take any accountability? Yes, I do, for watching you mess with underage girls, but I was minding my business. Why would you even say that? Nobody online would have known this. I mean, or maybe Fat Joe was responding online. Maybe I'm wrong about that. But it seems like this is just Dixon volunteering that somebody else was saying, "Are you going to take accountability for you being the one that did something?" And he's volunteering it to people that otherwise wouldn't know about that. Quote, "Stop moving around in the streets like you wasn't messing with the underage girl. You're a pedophile." Dixon further attempted to tarnish Cartagena's professional reputation and connections by explicitly tagging Cartagena's business connections in his defamatory posts. For example, Cartagena is the president of Urban and Latino Development of Market America, a product brokerage and internet marketing company. On December 6, 2023, Dixon posted about Cartagena, tagging Market America's Instagram account and writing, "Does Market America know they have a pedophile as their spokesperson?" Dixon's aberrant defamatory conduct continued throughout 2024. Also, I see Pam is here. Pam Entertainment TV. She says, "This case seems too messy and not in a funny way." It just seems like and I have questions about Dixon, but there are other people that Tyrone Blackburn has represented where I haven't I don't have an eyebrow raised at the client's claims necessarily. And what kind of service is that to someone that has valid claims to bring forward? Like, it's just such a horrible thing to use somebody as a vehicle, either to make headlines with the lawsuit or to get a settlement before it actually goes into the court system. So, yeah, it's messy. And then we have an arrest today, like for avoiding service. Like, if this is the other way around, Tyrone Blackburn would be having a field day on the internet right now. And QB says this is too much. Also, AV got out of here, but you guys make sure you're checking out AV again. A ton of Karen Reed content. A long time ago, she did coverage on the Little Rod lawsuit too. So if you want more Tyrone Blackburn content, we're gonna call it content. Tyrone Blackburn's filings. AV did a whole breakdown of the Little Rod filing. And Phoenix Rising says, "AV in the house, love women supporting one another." Heck yeah, always love AV. She's always got such good organization. When she's got something she's covering, she's got it from start to finish, the context for it. So she does a super good job over there. Um, for always, forever, for life, good advice. Says that's why when you find people are jealous and envious of you, you better run like hell. And we have some similar, that's advice that I would say could apply to the Relly and Rocky situation. And what's interesting is in one of the civil actions that Terrell Efron, Relly, has against Rocky, one of them is a defamation case, and Joe Tacopina is also named. But the defamation complaints really come back down to statements by Joe Tacopina, not statements by Rocky, and their statements to media about the criminal matter, where Tacopina was stating, my client is innocent, this is an extortion attempt. It's really not comparable to what's going on here. But it is interesting that Tacopina's on one side on the receiving end as an attorney, as a named defendant in a defamation case, versus what he's writing against Tyrone Blackburn, another attorney here. But to me, the matters underneath seem not comparable. Not comparable. Oh no. Keyshawn says 3 guarantees in life: death, taxes, and Tyrone Blackburn filing a shakedown lawsuit. Oh my goodness. Yeah, he might want to take a break for a little bit there. That's a good one. Oh no. And then Chloe says, "Rats, my Starbucks is glitching. The app says all food items unavailable. Send help." So we can't have this big gathering with Homeland Security at the Southern District of New York courthouses today. We can't do it until we get our food order straight. Oh my goodness. We have continuation here through 2024. So May 23rd, 2024, Dixon posts about Cartagena stating, Lil Joey was dating and having sex with a 16-year-old girl named Nikki, aka Shaquita, and had a full-fledged relationship with her for 5 years. And like, bring her in, bring her as a witness. I will be all ears and I'm open to taking in new information. I don't know if I believe it coming from this guy, though. June 15th, 2024, Dixon sent manager a WhatsApp message stating, Tell Lil Joey I got something he's afraid of, just when y'all thought he was untouchable. He instructed manager to tell your man this will end it all. September 20th, 2024. Dixon posted a picture of Cartagena, Sean Diddy Combs, and DJ Khaled to his Instagram account, stating, hashtag, Fat Joe, Nikki was underage when you flew her across state lines and out the country. October 1st, 2024, Dixon posted to both his Instagram and Threads account. Threads has entered the building. A post stating, Fat Joe had a full-fledged relationship with Nikki who was underage, and Fat Joe knew Dre was having sex with an underage girl because Joe was the guy telling him, calm down, we going to take care of it. Oh. On December 28th, 2024, Dixon posted to his Instagram account a post accompanying images of Cartagena with the following caption, hashtag, Fat Joe, Milwaukee was scary, the girl wasn't lying. So this seems like it's going back to the Wisconsin story. And quote, this happened in Wisconsin. Joe was being a thirsty N-word and almost got us locked up for sexual assault. Hashtag sexual assault. Almost got us locked up. The caption is accompanied by 4 headlines. It's officially over for Fat Joe. Fat Joe investigated for sexual assault. Fat Joe's ghostwriter TA the legend. What? We just put in a gratuitous compliment here. And Fat Joe, former employee, finally speaks out. C. Dixon falsely alleges that Cartagena cheated him out of money and credit. Beyond the false allegations of pedophilia and sexual assault, Dixon also falsely claimed that Cartagena underpaid him for his services and did not credit him for songs he allegedly wrote for Cartagena. For example, on March 17th, 2025, Dixon published a story to his Instagram account accompanying the headline of a video titled, Fat Joe Calls Ganju Roach a Liar. The story stated, you have a very long history of stealing and robbing people, and you stole from Pun and his family. This is going way back. You settled in court to pay Liaz Rios $2.3 million, not counting the rest of the money you stole. On March 18th, 2025, Dixon posted to his Instagram Threads account, or back on Threads, hashtag Fat Joe, don't never forget who kept you breathing. I wrote this for your homie. I wrote this for your homie. Dixon also published defamatory statements in an April 13th, 2025 interview on the Off the Books podcast. On the podcast, Dixon falsely alleged that Cartagena underpaid him for his services and did not credit him for songs he allegedly wrote for Cartagena. Dixon publicly published these statements on his social media accounts and in interviews knowing they were false. He plainly intended to humiliate and defame Cartagena, harm his reputation, and coerce him into paying Dixon millions of dollars that Cartagena did not owe. Dixon falsely made heinous posts about Cartagena and his wife. Dixon also attempted to pressure Cartagena by humiliating him and his wife. On January 22nd, 2024, Dixon asked manager to, quote, tell Joe I'm going to live to talk about that threesome his wife had. She's a nasty scumbag. You know that, right? Your boss a sucker. In another Instagram post, Dixon tagged Cartagena's wife and stated, you really don't think this safari grass back 3-inch pink slimy king jerk chicken spider. We've got the spider emojis. They're going to think it's affiliated with Young Thug. Path ass was cheating. What's a spider path? Was cheating on you so much that never even gave it a shot of being faithful. You don't care that he lived in the whorehouses. You don't care, question mark, question mark, question mark. You know what? I witnessed him getting his ass eaten. That N-word is out of control. 100 emoji. I got something special. Do you want it? No. What? What is it? This is one sentence. Oh, I guess besides the question marks. This is 2 sentences. Dixon even tagged Cartagena in a post that stated, tagged Fat Joe, should I blast one name off that your wife cheated on you with? Or should I wait to go into full detail? 100 emoji. It will hurt you. She's a beast. Is that how we spell sheesh? Is that like sheesh or sheesh? That's ridiculous. Sheesh. Dixon made countless other. No, this is what I was talking about. The videos. The videos. Oh my god. And Cash Money Cass, I'm not even gonna ask you to do skits on this one. I'm not gonna request it. Let's not do that. But it's super good to see you. Dickless. Dixon made countless other posts attempting to belittle and humiliate Cartagena. Many of these posts superimpose Cartagena's head on another person's body. So here you go, chat. Dixon hired Blackburn to continue. Oh, so now we're getting more with Blackburn in the picture. Let's see when he came in. Dixon hired Blackburn to continue his extortionate scheme. Frustrated by his inability to overcome Cartagena's resolve, Dixon upped the ante by hiring Blackburn and Blackburn Law to shake Cartagena down. But Blackburn is no ordinary lawyer. He is an extortionist masquerading as a lawyer in a cynical ruse to use the court system as both a sword and shield for his unethical conduct. Blackburn's gambit has not gone unnoticed. Just over a year ago, in April 2024, Judge Coates stated that a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. So we've read this, but indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Blackburn has called defense counsel in this action a disgusting racist for rejecting his preferred mediators. In response to this court's order requiring plaintiff to submit an affidavit regarding the representation made by plaintiff to counsel regarding Fisher's residence, Blackburn filed a wholly inappropriate 53-page paragraph affidavit containing multiple irrelevant and scandalous accusations against Fisher. So we looked at that earlier. We shared it in the chat. It's also over on X if you want to look at the full the full order. And less than a month ago, and this is April 29th that this filing was made. So less than a month ago from then, Judge Atkin issued a warning to Blackburn. This is in the Lil Rod case. Judge Atkin first stated that Blackburn filed, quote, admittedly false claims. Then, after reviewing Blackburn's filings, Judge Atkin concluded that they are, quote, replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. Blackburn also appears to be suffering from a personal crisis. An investigation report of the East Orange Police Department provides that on April 17th, 2024, Blackburn's girlfriend's best friend alleged that Blackburn was harassing her. Exhibit W, and I have that, so we'll look at that. Blackburn's girlfriend's best friend alleged that Blackburn was harassing her. According to the report, the best friend stated that Blackburn, quote, called her a bitch numerous times, texted her, I hope your mother has a life insurance policy because you are worth more dead than alive, and made various statements to her that she claimed were false. The report states that the best friend is in fear of her safety because she does not know what Mr. Blackburn is capable of. Blackburn's conduct regarding Cartagena appears to be more of the same. He has demonstrated a pattern of unprofessional and erratic behavior that raises significant concerns. Blackburn has repeatedly referenced unrelated cases involving other clients, often in an attempt to intimidate or distract from the issue at hand. In several communications, Blackburn has engaged in name-dropping celebrities seemingly to bolster his own credibility and to exert undue pressure on Cartagena. Most troubling, however, are the numerous emails sent well after business hours, which are characterized by a bizarre stream of consciousness style and contain vague, threatening language. Following the unsuccessful shakedown by the way of March 23rd, 2025 letter seeking compensation for songwriting and performing, on April 21st, 2025, Blackburn sent a second letter reasserting Dixon's demand for payment, the second letter. This time, however, Blackburn added outrageous false allegations of misconduct, including purported violations of the Trafficking Victims Protection Act for alleged acts of forced labor and coercive sex trafficking. As a plain indication of its lack of merit, the second letter lacked any specific allegations of purported wrongdoing, failing to specify a single instance in which Cartagena allegedly compelled Dixon to continue working for him or engage in a sex act. And if you go over, Happily Angry Lawyer broke this down again, like it's like vague who's doing what, and then it's not Cartagena and Dixon's not impacted, and the other parties that these things supposedly happened to are not, they didn't give statements, they're not part of the filing. It's just, I guess Dixon is claiming a grievance on behalf of somebody else, and that's not really the way this works, you guys. So interested in watching how that plays out. Obviously, a motion to dismiss, I guess in both cases, is going to be worth the read. And then, yeah, so for always, high four, high five. If this is true, this is so sad that all the favorite stars that I came up listening to are going down in a despicable way. And there's been like a lot of, things that come out and seem to have merits. And I'm not sure I reserve the right to change my mind with any new information, but I definitely have my eyebrow raised on this specific case. And it's that Wisconsin article, the idea that this 2010 situation in Wisconsin, yes, it could have surrounded a Fat Joe event, but the complaint was made against Dixon, and then Dixon's taking those headlines that use Fat Joe as a celebrity name to conjure a story over a decade later to imply that Fat Joe was the one the girl complained about. That's crazy. That's crazy. So I don't know how that will shake out, but if that's what Terrance Dixon is doing, it would seem that Tyrone Blackburn didn't vet his client, because he, at the very least, would have read the article about that complaint and seen what Tacopina and Chad Siegel are representing here as, no, the complaint was actually against Dixon. So at the very least, it seems like Tyrone wasn't vetting these claims in this case. That's aside from the issue with Brianna Bongalin over in the Combs case, who's saying, and to be fair, she was saying it after she was pressed about something you're claiming couldn't be true according to metadata. She could have just been pointing the finger over at Tyrone Blackburn. But she is saying, I fired my attorney, Tyrone Blackburn, because he said things that were false. So I just don't. And all sympathy to someone that has relied on an attorney that didn't care, didn't do things the right way, and been impacted because their advocate wasn't really an advocate. And that's just kind of where I see this going here for Tyrone Blackburn and several of his cases. Candace says, don't call Tyrone. Also, yes, Factual Lie. Speaking of good advocates here, Factual Lie says, subscribe to Hal. That's Happily Angry Lawyer. Remember, guys, he is doing pro bono work for Moonk. He's got some others that he's going to be covering, and also some filings in some other cases on behalf of others, not just Antonio Sledge. And as always, guys, any mod that has ever wanted to provide their Cash App information, that's always in the description of our live videos. I added Happily Angry Lawyers in there. He's technically a mod. We did it so he could share links to important resources. And I didn't ask him for permission, but he has his Cash App on his own channel. I've added it to the links with the mods in this description. If you want to support the work he's doing pro bono, remember, he quit his ritzy, lawyerly job and just was so pissed off about what was going on in the YSL case and beyond at this point. The way people are leveraging, overcharging, making mistakes on sentencing, getting people to take pleas, revoking probation, all of these different things. He was so riled up, he became an advocate without any money on the other end waiting for him. So I made the decision before the stream to put his Cash App in my descriptions moving forward. So just know that that's there. And it's free to go over and support his channel, and we can get him going. Chloe says he should have filed in Canton where metadata goes to die. You're right, right. No one ever would have known. JC from the D says this Blackburn guy is a toxic personality and an immoral person. That's the opinion I hold as well. So I'm with you there. And yeah, Trikisha, I think talking about Jim, happily angry lawyer, says he needs to start his own gig with the yellow heart. Um, I agree. We're gonna support. You should do, like coders. They build in public, like they'll code and show you the website live as they're building it or whatever. We could have Jim do a getting his Georgia bar license in public. We can study stream with him. That'd be pretty awesome. Definitely here for that, Hal, if you're still here. Where were we? Lack of merit. Didn't specify. Okay, despite Dixon's claims lacking any basis, Blackburn threatened to immediately file an already drafted complaint premised on Dixon's false allegations of forced labor and sex trafficking if Cartagena did not accede to Dixon's demands by April 25th, 2025. This demand gave Cartagena a 4-day window before Dixon would go public with his false allegations. They were in there. Tacopina and Siegel and Steve were like, let's get this thing written. On April 22nd, 2025, Blackburn sent an email to Cartagena's counsel, bizarrely threatening to report Cartagena to Homeland Security and file suit without further warning. He also claimed that he had video and other evidence to back up Dixon's claims. Now, this Homeland Security thing is just giving me recall, like to stuff with Diddy, right? Like it just seems, maybe civil attorney soliciting information, and when appropriate, if there's somebody in danger, I'm not trying to fault the process, but at the beginning of the stream, I talked about, creating a circular, self-supporting argument, because Tyrone Blackburn is arguing to judges, making representations of somebody's guilt or liability because there's other pending actions against somebody. And on the criminal angle, if you can get some criminal action going, that seems to be what Tyrone Blackburn was doing with civil filings. Oh, well, there's a civil accusation. Someone's accusing him in a lawsuit that I filed. Well, if you can get some criminal action stirred up, maybe you can say there's an arrest, there's an investigation, charges, DA's brought charges against, and though there hasn't been an arrest, can we stay this action and wait to see the results of the criminal action? And then maybe the outcome of the criminal matter can substantiate a civil claim later. Right? So very interesting that Blackburn represents a bunch of people in different cases, and we have this Homeland Security invitation, whatever that is, coming up. So on April 23rd, 2025, Cartagena's counsel spoke to Blackburn to discuss Dixon's allegations and ascertain why Blackburn threatened to call Homeland Security. So can you picture Joe? Like, why are you threatening to call Homeland Security? Oh my gosh. And again, by May 1st, don't forget, by May 1st, Tyrone Blackburn is characterizing it as an invitation for us to go sit down together. But by all representations in this complaint, it's a threat of one directional. Tyrone Blackburn's gonna go there and do this against your client if you don't cooperate. Big switch of words. Cartagena's counsel also asked Blackburn for the video evidence, quote evidence, of Dixon's claim, but Blackburn admitted he had never seen some of the video evidence he claims substantiates his client's allegations. You said you vet your clients. You make representations when you file that this is Rule 11 stuff. Here again, I don't think we're vetting our client. Further, Blackburn threatened to submit a sworn statement by one of Cartagena's former managers to, quote, corroborate the claims against Cartagena. On April 25th, 2025, Blackburn sent Cartagena's counsel a third letter containing even more vile and false allegations. Now, okay, so we have a 4-day window that we're saying we're going to file this new thing. And in our initial demand letters more than a month ago, we don't accuse Fat Joe of these sexual and heinous acts, even though Dixon's been posting on them all over Instagram since 2023. But Dixon only wants to send a demand letter about wages and lack of credit for songs he supposedly wrote and didn't get credit for. But then we upped the ante in April and we sent a drafted complaint and say, we're going to file this with all of this stuff in here. We're going to send it to Homeland Security. You've got a few days to consider this. And then when we give you a 4-day window, we're still eagerly following up. If I have leverage over somebody and I give them a deadline to do something, I'm not typically pestering them unless I need them more than they need me to do what I need to do. And in that case, I don't have leverage over them. So it doesn't seem to me that, oh, you have a 4-day window, but did you do it yet? Are you gonna give in to us yet? That kind of seems like you don't really want to file this thing for your sake. But that's my read on it. That's my opinion. On April 25th, 2025, Blackburn sent Cartagena's counsel a third letter containing even more vile and false allegations. So we're upping the ante against Cartagena and demanding that Cartagena pay Dixon a settlement payment of $20 million to release Cartagena from Dixon's bogus claims. The third letter, multiples higher than his previous 2.6 million demand, so around 3 million. The third letter again threatened that Dixon would, quote, initiate litigation immediately if Cartagena failed to accede to Dixon's demands that same day, and would also drag in one of his business partners, Market America. Blackburn's baseless threats were then repeated in a flurry of unhinged emails sent long after the close of business. All right, guys, we got bullet points. April 26th, 2025 at 9:52 p.m., stating that he was going to sue a business affiliated with Cartagena along with business owners. April 27th, 11:36 p.m., refusing to provide names of individuals Blackburn claims were making allegations against Cartagena. April 28th at 11:01 p.m., refusing to provide evidence and baselessly claiming that Cartagena's counsel was conflicted. April 29th, midnight, 12:15, playtime is over. So this is the day that this filing that we're reading is ultimately filed. So Tacopina, they got this ready and they sent this through. So they must have had this before they submitted this complaint. An honestly smart move. Blackburn repeated his heinous and false allegations against Cartagena on a call with Cartagena's lawyer on April 28th, 2025, during which he stated that he personally verified the alleged claims and spoke with certain critical witnesses, including one of the alleged minors, and that his $20 million demand was based on other cases which bore little resemblance of the facts herein. Was he looking at his other cases and saying, well, we asked for 20 million in another case, so that's why I'm going to ask you for 20 million here? He's like even using circular logic with his own demands. I can picture that. For example, to inflate his demand, Blackburn referenced how former National League football star Shannon Sharpe's attempt to settle a case for 10 million was turned down. In fact, Blackburn warned, quote, Tony Busby he just filed against Shannon Sharpe last week. And like Shannon Sharpe's career is damn near over now because of that. With that woman who is 19 years old and a model on OnlyFans or whatever it is, right? And he and Shannon Sharpe offered 10 million in mediation, to get rid of it, to try to resolve it. Tony Busby still filed, did not care. You know what? 50 million for a clearly consensual adult relationship. And like Shannon Sharpe got kicked off, and we're spelling his name wrong every time, but maybe that's Tacopina spelling it wrong. He got kicked off ESPN. He lost everything. End quote. On the call, I mean, is it clear that Shannon Sharpe lost everything? That still hasn't had its hearing yet. And from what I checked a few weeks ago, I don't think Zuniga served Sharpe, but maybe that's happened since. On the call, Blackburn also stated that he emailed Cartagena's lawyer a completely irrelevant audio recording without Dixon's permission. What? Interesting. And Blackburn followed up on his third letter and call with Cartagena's counsel with yet another email to Cartagena's counsel, this time threatening to bring a RICO claim against Cartagena. So we're adding the RICO on what, April 28th? Are we on April 28th? Yeah, we're adding a RICO. We're going to add RICO on April 28th. So a month ago, a month before this was just unpaid wages and credit not given. Then it became statutory rape accusations from someone that is not Dixon himself. And now we're going to add RICO when we said you had 4 days. Now you have to answer today. And now we're going to add RICO and we're going to bring in other names, other people. Just, I don't know, guys. But yeah, so he's following up. He's going to bring a RICO claim against Cartagena, supposedly concerning claims that have nothing to do with Dixon's and Cartagena's relationship or the allegations in Cartagena's demand letters. Adding insult to injury, when Blackburn last brought a RICO claim, Judge Atkin was flabbergasted that Blackburn argued that the defendants were presumed guilty of being a RICO criminal organization because they were subject to a grand jury indictment. This is the Lil Rod case. Judge Atkin observed that any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. So I wonder, yeah, so if that's the pattern, you try to get a payment out of somebody around like this $3 million price point. When they don't, you sue them, you put the civil filing through for $20 million. This Homeland Security talk, I mean, did Tyrone Blackburn try to go to Homeland Security or whoever he thought might want to prosecute something against Fat Joe? Did we take that action here? And if so, is something going to come of that? Or were they just like, nope, nope? Because it seems like that's the MO in other situations. So I'm wondering if, and based on the emails, if Tyrone Blackburn hasn't already months ago tried to ruffle up a criminal case. Blackburn's, and which I guess, where were they alleging all of this happened? It'd have to be other states, maybe. Blackburn's and Dixon's claims regarding Cartagena, or they'd have to have the actual complaining witness, right? It couldn't be Dixon. It would have to be the actual complaining witness for those, the sex crimes. Blackburn and Dixon's claims regarding Cartagena, both public and in the foregoing correspondence and calls, are false, and both Dixon and Blackburn knew those claims to be false when made. Dixon's and Blackburn's unrelenting efforts to humiliate and threaten Cartagena into an extortionate settlement agreement to avoid the painstaking efforts of publicly dispelling Dixon's lies have compelled Cartagena to file this complaint. So, first cause of action is defamation, and we're going to get some of these tweets that we read earlier. That this is the defamatory stuff, and again, not protected by litigation privilege. And I'd wonder if litigation privilege can, like, they could argue that the truth is a defense, but then they have to, prove why they believe it to, the standard preponderance of the evidence. But since I don't think Dixon can make a claim, or Dixon can't sue directly for statutory rape when this allegedly happened to a different person named Nikki. So even if there was a civil action, yeah, I don't know. This one's going to be, I don't know. I can't wait to see the motions to dismiss on both sides. Let's see. We've got the Fat Joe one, the picture of Diddy. So we're just reciting all of the Instagram and Threads posts that were discussed earlier as what gives rise to the cause of action of defamation. He intentionally published these false statements to his publicly accessible social media accounts, which third parties viewed and commented on. So exposure to a different audience. Dixon had neither privilege nor authorization to publish such false statements to third parties. Dixon's statements also constitute defamation per se, because it's involving claims of sex assault and statutory rape. Such accusations of crimes of moral turpitude tend to injure a person's trade, business, and profession. And then on top of it, he's tagging the business associates. Let's see, publicly available and intended to harm. And they are seeking an award of damages in an amount to be proven at trial, but in no event less than 15 million plus interest, an award of exemplary damages, an award of attorney's fees. Second cause, and now we're getting Blackburn in the mix, is intentional infliction of emotional distress. So we're getting some of Jess Dixon's posts. And more of these posts, the podcast. Dixon escalated his campaign of harassment by sending Cartagena extortionate demand letters through his attorney, Blackburn, threatening to initiate frivolous lawsuits with false accusations of statutory rape, forced labor, and coercive sex trafficking. On March 23rd, 2025, Blackburn sent Cartagena a baseless demand letter alleging that Cartagena underpaid Dixon and denied him credit for his contributions to Cartagena's success under their oral agreement, and demanding retroactive songwriting credit and monetary settlement. Then when he refused, and they're repeating this, right? Because this is to establish this cause of action, right? So we've seen the outline. They've laid out the facts above, the facts that they're alleging. And now this is how this would support a claim of intentional infliction of emotional distress. So they send that, then they up the ante, they add more stuff, and they're demanding payment in return. And in return, they're going to threaten to file a lawsuit alleging the same if Cartagena fails to accede to the demands within 4 days. They up the ante again on April 22nd with Blackburn emailing Cartagena's counsel, bizarrely threatening to report Cartagena to Homeland Security and file suit without further warning. The next day, we get the calls, more on the Homeland Security. And then Blackburn further admitted that he has never seen some of the videos he claims support the allegations against Cartagena, and threatened to submit a sworn statement by one of Cartagena's former managers to corroborate the claims. They extort for the 20 million. And I guess I shouldn't say extort. They're not alleging that here. They're just saying demanding. This is where they want to include Market America. I mean, this is what it should look like, right? How, intentional infliction of emotional distress, you're doing it. This is how it would cause the distress. These were the actions that the parties were claiming, right? Because we've got to show not just Dixon. We're also bringing this cause of action against Tyrone Blackburn and the law firm. So we've got to show what they're doing as well, and that it's not just Dixon, and because you're the attorney for Dixon, you're somehow liable. No, it's because of Blackburn's participation. And then what do we get after that? Okay, so here they're looking for 15 million plus interest. It says he will suffer additional significant special damages, including loss of business opportunities, harm to his professional reputation, and financial setbacks once Dixon's and Blackburn's allegations become public. So no less, because there's future damages. Let's see. And they're also asking for injunctive relief. So restrain the defendants from engaging in further conduct of the type alleged herein. The award of damages to be proven at trial, the exemplary damages, and award of attorney's fees. So we'll see if we get, any type of restraining order there. And then the prayer for relief. So wherefore, Cartagena respectfully prays for judgment and relief against Terrance Dixon as to both counts, and Tyrone, we have a misspelling, Blackburn, and the TA Blackburn law firm on count 2 as follows. So damages of 15 million plus interest, no less than 15 million. Entering a preliminary and permanent injunction restraining defendants from engaging in further conduct of the type alleged herein. An award of exemplary damages, an award of attorney's fees, and such other and further relief as this court may deem just, equitable, and proper. And then demand for jury trial for all issues so triable. So there you go. This was what was filed on April 29th. And I don't know. I think the substance of the exhibits was pretty much quoted. It's just the exhibits are probably screenshots of. Let me pull up Pacer. I feel like those exhibits are just the um like screenshots of the messages. So I don't think we need to grab those unless you guys think any of them might be something different. But I do have the complaint, the police report, where Tyrone Blackburn's girlfriend's best friend is saying she's afraid of Tyrone Blackburn. So where was that? Where was that one? I did have it open, but I closed it when I was closing my barrage of tabs. Um, and in the meantime, you guys, while I'm looking, other cases. So Courtney Clenny's hearing, she had a hearing today. It was continued to July 2nd. Do you guys know the Lindsay Shiver case with former football player Robert Shiver? I saw she has a case because she's held in the Bahamas. That's where she's being held. And it said she has a hearing coming up on July 5th, which would be Saturday court. So I don't know about that, but I haven't seen motion in that case for a while. It's alleged that she was trying to hire a hitman to kill Robert. So she's been in custody. She was out on bond and then she's back in custody. But there hasn't been motion on that in a while. I mean, that's been happening for like 2 years now. So that's coming up supposedly on July 5th, a Saturday. What else we got going? One of the Relly and ASAP Rocky there's like a order to show cause for Camille Vasquez because nobody showed up for one of Relly's hearings. No one showed up on his behalf. So there's been a show cause order on the docket since like January. I don't know why it's July that it's going to happen. Tony Busby, lots of back and forth with the Jay-Z actions in Alabama and California involving Tony Busby. That's interesting to follow. I haven't done a stream on it, but I've covered all the filings on over on X. And I don't know where. I'm not finding it. It was like an ugly screenshot that I posted of this stupid thing. And Brooklyn's here. Brooklyn NYC says, "Hey KNW chat, finally made another live. I'm listening it 2 times to catch up. Hopefully y'all still streaming when I'm caught up. Note, Blackburn is one of the slimiest fame seeking attorneys license." Well, you're gonna get a lot of stuff that seems to back that characterization up. Oh, and then Halle Bailey DDG. There's the hearing yesterday was continued to tomorrow. Uncle Tino over on X, cousin Tino is funny. He was in the courtroom yesterday. There was no broadcasting allowed. But they've got some stuff to work out to see if DDG can travel to Italy and see Halo while Halle has Halo in Italy. But Halle doesn't want DDG's mom to be the individual that does the handoff. So they have to find a person, a professional that can travel to Italy. Like, imagine if you didn't have money to do this. Like, this would totally be this would be out of the realm of possibility. But a person that would be hired for the sake of going and doing the handoff while Halle and DDG have a no contact with each other to make sure Halo can go from Halle to DDG and then from DDG back to Halle. So I think the parties have been looking to find a professional person to make this happen. And they've got to confer with the judge tomorrow if they made it work. So that was a little update on that case. Sorry, I've posted so much in the last few days, mostly because of Karen Reed drama, that I just don't see it. But I swear I posted it on X. It was a really dark photocopy of the police report. Oh, Halo is so cute. I didn't even know until like a couple months, well, more than a couple, New York couple, more than two, a few months ago that that was Halo. I just would see all the meme faces. People would use Halo's face as a reaction to a bunch of stuff. Um, I'm all the way back to like the Ian Runkle video. Okay, wait, I'm getting to some Tyrone Blackburn stuff. Uh, I'll just download it again because I think I was on my laptop. That's why I'm not finding it. Yeah, Queen Shadina, he was arrested today according to TMZ, but it was for an incident in May. So, and it was in New York. So either they were investigating and then decided to put out an I-card or a warrant for his arrest, um, or they just haven't been able to find him, even though I think he's been in New York for the Diddy trial. But um, that's the Dixon case. Where is, okay, Cartagena. Oh, oh, wait, chat. We have a motion to dismiss, and we have some letters. Oh, no. This was the 23rd. Okay, chat, we might go a little longer. Okay, wait, an extension of time to answer back on June 2nd. Letter addressed to judge from Jordan. So this is attorney for Fat Joe regarding related actions. So it seems like Joseph is making it known, hey, there's this other filing. This is available. So let's just double check that. Yeah, so they're naming the other case. We got two cases here. We, along with Tacopina, Siegel, and Diorio, represent defendant Joseph Cartagena and submit this letter about two closely related actions currently pending before your honor. So we have Cartagena v. Dixon, the first filed action, and Dixon v. Cartagena, the second filed action. As discussed below, they both arise from the same transactions and occurrences, thus under federal rules of civil procedure, which I hope the judge is like, yeah, Tyrone Blackburn, you should have filed it this way to start. Dixon was required to assert the claims in the second filed action as compulsory counterclaims and third-party claims in the first filed action. Guys, he's going to get in trouble again. Tyrone Blackburn, they're going to be like, don't you know how to file things? Accordingly, Cartagena respectfully requests that the court either stay or dismiss the second filed action without prejudice to Dixon, refiling his claims, spurious as they may be. Oh my God. As counterclaims and third-party claims in the first filed action. In the alternative, Cartagena requests that, pursuant to Local Civil Rule 16 and Rule 13b3 of the Rules for the Division of Business among District Judges, the court deem both lawsuits related, in which case Cartagena will promptly move to consolidate them. I don't know if we need to go in the background of the cases. Then it says nearly 2 months after Cartagena brought the first filed action, Dixon and Blackburn followed through on their scheme by filing the second filed action against Cartagena and others. Rather than assert their claims in the already pending first filed action today, their twice extended response date after having failed to timely respond, they initiated a separate lawsuit on this court, June 19th, which was assigned to your honor on June 20th. Oh, I want to see what the judge says. Repeating the same false and sensational allegations that are the subject of the first filed action. This tactic is consistent with the pattern identified by at least two Southern District of New York judges who have found that Blackburn's pleadings are replete. Here we go with the quotes again from the Lil Rod case. Replete with inaccurate statements of law, conclusory accusations, inappropriate ad hominem attacks on opposing counsel, and are designed primarily to garner media attention and embarrass defendants. Guys, oh my God, are we going to have a judge? Get it together, Tyrone. Oh my goodness. The second filed action should be dismissed without prejudice or stayed. Federal Rules of Civil Procedure 13A provides that a pleading must state as a counterclaim any claim that at the time of its service, no wonder he was trying not to be served. He wanted to file a separate complaint. The pleader has against an opposing party of the claim. A arises out of the transaction or occurrence that is a subject matter of the opposing party's claim. And B does not require adding another party over whom the court cannot require jurisdiction. And it's really important that leading up to the final hour, we just read what the complaint alleged, the first filed case. It alleged everything that Blackburn and Dixon said they were going to do up until like a few minutes after midnight on April 29th. So all of that upping the ante is stuff that is included. All of those transactions, those occurrences, those matters are included in reference and incorporated into the first filed filing. So I don't know how they'll wiggle out of this one. I can't wait to see it though. The factual allegations in both the first filed action and the second filed action arise from the same nucleus of operative facts: Dixon's and Blackburn's campaign of false extortionate accusations and threats to file a fabricated lawsuit against Cartagena, and Cartagena's response to those actions. The second filed action is, in essence, a core component of the first filed action, with Dixon and Blackburn reasserting the same allegations that prompted Cartagena's first filed action. Accordingly, because Dixon should have asserted these claims as compulsory counterclaims and third-party claims in the first filed action, the court should either stay or dismiss the second filed action without prejudice to Dixon refiling his claims as counterclaims and third-party claims in the first filed action. And then they cite Adam v. Jacobs. Once the court becomes aware that an action on its docket involves a claim that should be a compulsory counterclaim in another pending federal suit, it will stay its own proceedings. This is relying on another case, dismissing second filed action and stating that when faced with duplicative litigation in an earlier filed action as here, the decision whether or not to stay or dismiss a proceeding rests with a district judge's discretion. C, in the alternative, both lawsuits should be deemed related, in which case Cartagena will promptly move to consolidate them. So at minimum, the cases should be deemed related. Rule 13A2 of the Rules for Division of Business provides that civil cases are related where the interests of justice and efficiency will be served, and sets forth 4 factors for determining relatedness. A, whether the actions concern the same or substantially similar parties, property, transactions, or events. B, whether there is substantial factual overlap. C, whether the parties could be subjected to conflicting orders. And D, whether absent a determination of relatedness, there would be substantial duplication of effort and expense, delay, or undue burden on the court, parties, or witnesses. All 4 factors are satisfied here. So first, it's the same core parties, Cartagena, Dixon, and Blackburn. The only meaningful difference is the alignment of the parties as plaintiff and defendant, but the underlying dispute and the core individuals involved are substantially similar. Cartagena submits that the additional parties sued by Dixon have no place in this action, but in any event, their inclusion centers on the same facts at issue at the core of dispute. Second, as discussed above, the factual allegations in both lawsuits arise from Dixon's and Blackburn's campaign of false, extortionate accusations and threats against Cartagena, and Cartagena's response to those actions. There is a substantial, if not complete, factual overlap between the cases. I just popped into my head, what if Tyrone Blackburn was on his way to a lunch and learn, to a meeting with Homeland Security, and that's when they ended up arresting him? He flew in to New York, he caught a flight to New York, and he lands, and he's ready to go to Homeland Security, and the police, NYPD, whatever, they're like, oh, hey, we have this warrant for you. Let's take care of that. Let's take care of that. Just randomly thinking about his Homeland Security invitations. Anyway, third, the second filed lawsuit is baseless and is part and parcel of Dixon and Cartagena's ongoing extortion scheme. However, even assuming arguendo that the second filed lawsuit were to proceed beyond the pleading stage, with parentheses, which it should not, both the first filed action and the second filed action would involve the same witnesses, the same evidence, and the resolution of many of the same legal and factual issues. Likewise, there is a risk of inconsistent or conflicting rulings if the cases proceed to trial at different times and before different juries. Um, and I think this is something that's very interesting for watching the Carter and Tony Busby, the Alabama case and the California case, watching those kind of proceed forward slowly but in tandem with one another. And the Carter is using representations by Busby in relation to the Alabama case to argue in the California case. So, there's a bit of a strategy there I think Carter's leveraging. And here, Tacopina is making the argument like this is both the Southern District of New York. It just makes sense to bring these together. Allowing these actions to proceed separately would result in unnecessary expense and burden for the parties, witnesses, and the court. So accordingly, both lawsuits should at minimum be deemed related, in which case Cartagena will promptly move to consolidate. So for the reasons stated above, the court should either stay or dismiss a second filed action without prejudice to Dixon refiling counterclaims and third-party claims in the first filed action. In the alternative, the court should deem both lawsuits related, in which case Cartagena will promptly move to consolidate them. Respectfully submitted, and this is Jordan Sieve. So, and that'll be, if you guys hear that this Dixon case is dismissed, make sure, read a little bit further into any articles about that, because it could just be this coming to fruition. It's dismissed, but without prejudice, and the expectation would be that it would just be refiled and or consolidated. So, let me do a quick Google search and see if we have any, because I would imagine if he posted bond. Let's see. The most recent thing I think is just talking about the arrest. Yeah, arrested Wednesday. Talking about the suit. Yeah, so nothing about anything since. He's just been booked, and Blackburn did not immediately respond. So I don't imagine that this is, I don't know what they're just charging him with assault. So because it's an assault charge, I don't really think they would deny bond. But I don't know. But we will look. We will look. So that was this most, what is it, June 23rd? Then what do we have? First letter addressed to Judge Jennifer Rochon from Tyrone Blackburn, also the 23rd, regarding opposition to defendant's 23rd letter, request to stay or dismiss document. So let me get this. Okay. Well, actually, let me download it. That way I don't lose it. So what is this? This is the June 2025, 06, 23, Blackburn opposition. 23rd letter. Stay. So since I don't have these in a drive, I'm not going to drop them in the chat, but I will add them to the folder of all the documents at some point. What do we have here? So this is 4 pages. Let's see. Oh my God, this is so close together. Opposition to defendants, June 23rd, 2025. Letter request to stay or dismiss. Dear Judge Rochon, we represent plaintiff Terrance Dixon in the above captioned matter. We write in opposition to defendant Joseph Cartagena's June 23rd request seeking dismissal, stay, or consolidation of this action with the earlier filed matter Cartagena v. Dixon. Defendant's request mischaracterizes the nature of plaintiff's claims, misapplies Rule 13a of the Federal Rules of Civil Procedure, and seeks to obscure the gravity and independence of plaintiff's trafficking and RICO allegations by miscasting them as a retaliatory response to a defamation suit. 1. Defendant improperly attempts to collapse human trafficking claims into his defamation narrative. Contrary to defendant's assertions, Dixon v. Cartagena is not a rehash of Cartagena v. Dixon or a defamation response. Instead, it is a distinct and well-pleaded civil action under the Trafficking Victims Protection Act, TVPA, RICO, and related state tort doctrines. The complaint alleges that from 2008 through 2024, defendants used his public persona and private enterprise to engage in a longstanding pattern of sexual coercion, forced labor, economic intimidation, and retaliatory threats, all supported by extensive factual detail and corroborated by witnesses that we won't name. Defendants now attempts to recast these claims as part of a, quote, defamation and extortion campaign, and argues that the TVPA and RICO claims should have been filed as compulsory counterclaims. This is a distortion of both the factual record and applicable law. The alleged trafficking enterprise predated the parties' current public dispute by more than a decade. The complaint does not hinge on defendant's defamation suit. It stands on its own as a civil enforcement of statutory rights. Courts reject efforts to reduce trafficking and forced labor allegations to reputational disputes. These claims concern the abuse of power, control, and manipulation over a vulnerable individual. Who was the individual that you're claiming in your pleading? Because Terrance Dixon's the party. Allegations that implicate serious federal interests. No court has ever held that a TVPA or civil RICO claim must be brought as a counterclaim to a defamation lawsuit simply because the defendant is a public figure. That wasn't Joe's argument. What argument is this addressing, chat? What argument are we addressing here? Also, I see some faces over here. We have Fact Check TV in the building. It says your life starts falling about when you build yours on the downfall of others. Selling your soul has repercussions. Right? And I think that's the way it should be. You kind of want to make sure, if there is no downfall to doing wrong, then there's no deterrent for people to do wrong. Kissin' Pink is here. Love the hoodie. Yeah, it's like a sweater thing, but it does have a hood. I love things with hoods, and when the end of the sleeve, this doesn't have it. But when like jackets sometimes have built-in thumb holes, so you don't need to wear gloves. I love those features on clothing. And internal pockets, zippers, anything that can keep things in pockets without falling out when you're out and about. We've also got Michelle. Michelle says Blackburn, Busby. Yeah, I know I'm going to say Tyrone Busby. Mitchell Kidd, that's a new name. Toss tells. Can't wait until their grifts are up. So I don't know the other two names, but Blackburn, Busby, definitely. I'm scared I'm going to use them interchangeably, and I don't mean to, but initials T and B for both of them. And then Sunshine for You One says, good afternoon, cat and chat. Forgive my tardiness. No worries. No worries. Heck yeah, Chloe's also a fan of the thumb holes and hoods on coats. It's great. I think it's a very good thing to have in New York too, when the weather can change. Well, the weather can change everywhere, but I mean, it can be hot and rainy and windy and then cold and frigid while you're walking through wind tunnel New York City blocks. Here we got the second argument. I still don't know who made this argument in the first part, and we don't have case law or anything, but okay. Defendant's defamation framing ignores actual malice and public figure standards. We didn't ignore actual we didn't do that. So this is let's see. And hold on. So this is being filed. Is he using the right? Okay, so he is filing this regarding Dixon v. Cartagena. Okay, because I was going to say we're using defendant here. But that means he's not a... Let me make sure I'm not crazy. So... Okay, so the letter was filed for the second case. So this makes sense. Blackburn actually has this one right. So defendants, which here means Fat Joe. Defamation framing ignores actual malice and public figure standards. Under Rule 13a, a claim is compulsory only if it arises out of the transaction or occurrence that is the subject matter of the opposing party's claim. Courts interpret this standard narrowly, focusing on whether the claims share a, quote, logical relationship. And that's Jones versus Ford Motor Credit Company. That test is not satisfied here. The defendant's defamation suit arises from a February 2025 demand letter and subsequent public commentary. Subsequent? No. This is incorrect. The defendant's defamation suit, this is the first case filed, arises from February 2025 demand letter and subsequent public commentary. No, the defamation included screenshots of stuff from 2023. So what is this? This is not right. In contrast, Dixon v. Cartagena involves years of prior conduct, spanning multiple states, involving enterprise participants, and implicating both federal labor and organized crime statutes. This is boldly incorrect. This first sentence here. And this judge is going to be able to look at both of them. Why would you even say this? Just say that it involves different material matter. While defendant would like to treat the trafficking claims as a publicity stunt, they allege a pattern of exploitation and coercion that far predates and independently supports plaintiff's complaint. Rule 13a does not authorize the dismissal of independent statutory claims merely because they touch the same public figure, nor does it require a trafficking victim to forfeit relief unless he responds directly to a reputational claim in the first filed action. 3. The defendant is a public figure subject to actual malice standards. To the extent defendant's letter implies reputational harm from plaintiff's allegations, defendant is a public figure subject to the heightened, quote, actual malice standard for any defamation-based relief. I don't think that this was missed. And I don't know how these are standalone arguments. It's like we went into a different argument entirely in the middle of argument 2. And then restarted the argument we were supposed to make in argument 2 in argument 3. The showing of fault necessary to recover for libel varies depending on a plaintiff's position in society, requiring a higher degree of fault for public officials and public figures. We got into this in the complaint we read, the April 29th complaint. You know, we even got the distinction of defamation per se, or alleging acts that are so heinous that it's implied to be inherently injurious. A public figure must plausibly allege that the statements were made with knowledge that the statements were false or with reckless disregard to their falsity. No, this Tacopina, Siegel, they laid that out. It was alleged that the statements were false and Dixon knew they were false when he made them. And I mean, I guess plausibly is a subjective characterization here, but you know, when you're doing a filing, it just has to be a prima facie showing. So, assuming what's being alleged is true, I mean, I don't see how you could look at that filing and say that Cartagena didn't allege that Dixon knew the statements were false when he made them. It was alleged more than once. So, courts have repeatedly dismissed defamation claims that fail to plead actual malice with specificity. I mean, maybe we'll see this. Maybe the judge will agree. Maybe it's not specific enough. Cartagena's letter fails to show how plaintiffs' independently substantiated trafficking claims could ever satisfy that burden. The attempt to characterize serious... This is more like a motion to dismiss argument. Why is this in a letter opposing the stay and or dismissal or consolidation? This seems like a motion to dismiss argument. Why are we here? Why is this here? Cartagena's letter fails to show how plaintiff independently substantiated traffic claims could ever satisfy that burden. The attempt to characterize serious civil rights allegations as a, quote, false narrative or, quote, extortion attempt is precisely the sort of conclusory and speculative framing that courts reject. See also themed restaurants versus Zagat survey. Moreover, courts may deem a party a public figure at the motion to dismiss stage where the pleadings suffice. Yeah, but we're about to get there, but this isn't what this letter's for. Defendant, it's like he's acknowledging that this is where his brain is, but this isn't the right letter regarding a motion to stay. I mean, I guess it's a motion to dismiss the second claim, but he's writing this as a motion to dismiss the initial claim. Ugh, I'm irritated. Defendant's public prominence as an entertainer, business owner, and frequent commentator qualifies him as a limited purpose public figure at minimum. I mean, I don't think that to me is arguing the first pleading. For consolidation or related case designation would be improper and prejudicial. So now we're back on topic. There is no legal or factual basis to consolidate the two cases or deem them related under Local Civil Rule 16. Relatedness requires substantial factual and legal overlap, not the mere identity of parties. The plaintiff's claims allege statutory and constitutional violations, not reputational harm. And this plaintiff would be, again, referring to Dixon. They involve different factual timelines, different causes of action, and different types of harm. The defendant, Fat Joe's desire to obscure those distinctions through procedural consolidation should be denied. Once the court reviews the motion to dismiss in Cartagena v. Dixon, it will be abundantly clear that there is no legal or factual basis for that action. Defendant fails to plausibly plead actual malice as required under New York Times Co. v. Sullivan. That's an oft-cited case. And its progeny. As a public figure, Cartagena bears the burden of demonstrating that plaintiff acted with knowledge of falsity or reckless disregard for the truth, yet the complaint is devoid of any specific allegations supporting that standard. What do you mean? Did we not just read the complaint, chat? Yes, he bears the burden of demonstrating. But at this stage, it's just got to be an allegation. And it was alleged. And he's saying, yet the complaint is devoid of any specific allegations supporting that standard. The standard that plaintiff acted with knowledge of falsity or reckless disregard for the truth. It was alleged that he acted with knowledge of falsity. Am I lost? The complaint's conclusory assertions are legally insufficient, and the case should be dismissed with prejudice. So in conclusion, plaintiff's trafficking, forced labor, and enterprise liability claims are not subject to Rule 13a. Defendant's request to dismiss, stay, or consolidate is based on a deliberate mischaracterization of the factual record and applicable law. For what it's worth, we didn't actually get that substantiated in this argument up here. We didn't have case law for this argument. We didn't back this argument up. So we're just asserting, and maybe it's well known. Maybe it's black letter law. But we'll see. The court should deny the request in its entirety and permit this action to proceed independently on the merits. So there we go. There's that one. Let me download this initial letter. I'll get them all in a file. Let's see. This was Cartagena. Letter. June 23rd, letter to stay. And then what else we got going? So where were we? Did that one. First motion to dismiss. Okay, so this was I think this is just the shorter motion to dismiss, but this is the memorandum of law and support. So this would be the beefy one we actually want to look at, and it's already available. Let me double check that this is just like the 2-pager. Okay, yeah, so this one looks like he's just attaching a proposed order and then his filing, because this is 158 pages. So I don't want to spend a bunch of bucks downloading that again. But let's see if we can just get the order. Okay, so in short, the one says it's the notice, but I want to see what this affidavit says. Um, all right, so yeah, definitely an affidavit we haven't seen. Let's see if I can get this up quick so you can see it. Sorry, I've got to upload it to Drive real quick so that way we can actually pull it up on stream. So this one that we're looking at right now will be on in the Google Drive linked in the description right away if it lets me upload it. And we'll call that Blackburn affidavit. Okay. So affidavit of Tyrone Blackburn submitted in conjunction with this notice of motion to dismiss. So again, this is in relation to the case where Fat Joe is the plaintiff. So this affidavit, I, Tyrone Blackburn, hereby declare I am the managing attorney of TA Blackburn Law, counsel for defendants Terrance Dixon, Tyrone Blackburn, and TA Blackburn Law in the above captioned matter. I submit this declaration in support of defendant's motion to dismiss the complaint according to Federal Rules of Civil Procedure 12b6, 8a, and 9b. And is it only him? Yeah, so he's not getting any other counsel. He's just going it alone. As set forth more fully in the accompanying memorandum of law, plaintiff's complaint fails as a matter of law. The defamation claim does not plead facts showing actual malice as required under New York Times Co. v. Sullivan, nor does it allege falsity or overcome the substantial protections afforded by the First Amendment and New York's litigation and anti-SLAPP privileges. The plaintiff's intentional infliction of emotional distress claim is duplicative of his defamation theory and independently deficient. No, it isn't. It isn't, because that's where we get the claims for money in play. So how is it duplicative of his defamation theory? And independently deficient for failure to allege outrageous conduct or severe distress as required under New York law. Attached here too, as Exhibit A, is a true and correct copy of the complaint. So that it was the complaint in Dixon v. Cartagena, which sets forth in detail the factual basis for the challenge statements. That action includes claims under the Racketeer Influence and Corrupt Organizations Act and the Trafficking Victims Act, and remains pending before this court. The statements at issue at the instant case are either quoted directly from that litigation or were made in anticipation of it. Accordingly, they are absolutely or qualifiedly privileged under New York law and are protected speech within the meaning of the First Amendment and New York civil rights law, 70A and 76A. Now, I didn't thoroughly look at all 156 pages, but I believe we have, maybe not for count two, the stuff that was like 2025 involving Blackburn, but I don't think everything from there was incorporated in the proposed litigation that wasn't even relayed until the final week of April to Cartagena and Tacopina. But I'm pretty sure I didn't see screenshots of the tweets of Dixon. I didn't see all of them reincorporated into this litigation. So not really sure that this argument would fly, but I guess we'll wait and let a judge decide who would know better than me. For the reasons stated in the accompanying memorandum and based upon the pleadings and record in this matter, defendants respectfully request that the court dismiss the complaint in its entirety with prejudice and grant such other relief as deems just and proper. I declare under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct. Did he make an affidavit to make arguments? Like, why is this a declaration? Why is there a declaration of the things I should be arguing in the motion to dismiss? Like, because I put it in a declaration, because I put it in an affidavit, now I can rely on my own affidavit as a fact. I can rely on the argument I make in a declaration as if it's a fact to support my argument in the motion to dismiss. This what? I'm not a lawyer, so maybe there's something I'm missing, but I don't think this is the way that declarations are supposed to work. I'm not supposed to make a declaration of my own argument to rely on in a subsequent motion that I'm gonna file. Oh my gosh. So now we're gonna look at that. That's the next thing we're gonna look at. How do I get back to this thing? All right, let's go back over here, chat. Cut the Radio podcast. This is, we're really looking at the first lawsuit, what Fat Joe filed, defamation, and intentional infliction of emotional distress against Terrance Dixon and Tyrone Blackburn. But when we pulled up the docket to look for some exhibits, there was some stuff filed on Monday. so now we're looking at all of that. And this one might be a little bit longer, you guys. This memorandum in support. This is where the beef would be. So 23 pages. Let's just do it, chat. Let's just do this. Let me save this real quick so I can drop it in the folder later. And this was 23. This was filed. Blackburn motion to dismiss. Like, he's already tried to do a motion to dismiss in the letter. Guys. So June 23rd. So Monday we have this. By Tyrone Blackburn. Got a table of contents. We have some case law coming in. That's good to see. Let's see. I feel like he has a lot more text crammed on page than I'm used to seeing. Preliminary statement. So we've got a preliminary statement that this case must be dismissed because it fails as a matter of law under Federal Rules of Civil Procedure 12b-6, 8a, and 9b. Plaintiff Joseph Cartagena, also known as Fat Joe, is a Grammy-nominated public figure who filed this lawsuit as retaliation after defendant Dixon exercised their right to speak out regarding allegations of exploitation, fraud, and abuse. The complaint is nothing more than a constitutionally impermissible effort to silence criticism through aggressive and meritless litigation. The claims are legally deficient in several ways. First, the defamation claim fails because plaintiff, undisputedly a public figure, has not alleged any facts showing actual malice, as required under New York Times Co. v. Sullivan. In that landmark decision, the Supreme Court held that defamation is not a strict liability tort, and that public figure plaintiffs must establish, by clear and convincing evidence, that the allegedly defamatory statement was made with actual malice, that is, with knowledge of its falsity or reckless disregard for its truth. Plaintiff fails to do so. Second, the intentional infliction of emotional distress, IED claim, is both duplicative and independently deficient. It is well settled that defamatory statements generally cannot constitute the extreme and outrageous behavior required for an intentional infliction of emotional distress claim. New York courts routinely dismiss IED claims when the underlying allegations are already actionable under traditional tort theories such as defamation. Courts have consistently held that emotional distress stemming from defamatory speech must be addressed within the confines of a libel claim, not through IED. Now, again, we talked about this, and I'm going to clip this part out, you guys, if you just want to look at this document. So if you're watching that clip, we talked about this in the full stream. The IED claim relates to the request for money. So this argument doesn't address why the cause of action, the second cause of action in Cartagena's complaint, was filed and the allegations it's relying on for it to be an intentional infliction of emotional distress claim. This is the second document now that we're looking at where Blackburn is misframing it as if it's just, he defamed me and it caused me emotional distress. No. He tried to ask me for money in relation to things that he wanted to claim. And that back and forth is what's being alleged to be intentional infliction of emotional distress. The defamation stuff didn't even involve Blackburn, but the second cause of action names both Blackburn and Dixon. Separate things. And Blackburn's not addressing that. He's misframing what was being raised as this IED claim. Moreover, even if considered independently, plaintiff's IIED claim fails on its merits. To prevail, a plaintiff must establish 4 elements. 1, extreme and outrageous conduct. 2, intent to cause or reckless disregard for a substantial probability of causing severe emotional distress. We got those things alleged. We had we had him lay out in this cause of action that it was outrageous. I'm pretty sure we got references to judges' characterization of other activities by Blackburn. Like, this stuff wasn't lacking in the filing. A causal connection between the conduct and the injury, something that a judge has admonished Tyrone Blackburn for not accomplishing. And 4, severe emotional distress. Courts evaluating such claims typically focus on the first element, whether the conduct alleged is so outrageous as to go beyond all bounds of decency. Here, plaintiff identifies nothing more than social media accusations and litigation threats. So now we're actually bringing in the litigation threats. We're finally acknowledging that as being part of these claims, which contradicts the argument made in this paragraph. These are not even close to the type of conduct deemed sufficiently outrageous under New York law. And he cites Howell, noting that the standard for IIED is rigorous and difficult to satisfy. Third, plaintiff's allegations lack the specificity and plausibility required by Rules 8A and 9B. The complaint is replete with conclusory allegations, speculative inferences, and irrelevant material. Interesting, because this is some of the same language that Judge Otkin used to characterize Tyrone Blackburn's filings in the Little Rod case. So that's interesting. I'm like, these words seem familiar. It reads as a retaliatory narrative aimed at discrediting defendant Dixon and his attorney, Tyrone Blackburn, not as a good faith effort to seek judicial redress. Let's just make sure this is only, he said by Tyrone Blackburn at the top here. By Tyrone Blackburn. And only Tyrone Blackburn. So just double checking. That's the only party writing this complaint. Where were we? In fact, the context surrounding this case, including Dixon's parallel lawsuit filed on June 19th, 2025 against Cartagena, confirms the context, including the case we filed. So the case is helping us confirm that the statements at issue arose directly in response to serious allegations of trafficking, labor exploitation, and sexual abuse, many of which are supported by detailed factual assertions, corroborating witness statements, and documentary evidence. Now, what's the problem here? He's not addressing the time period before that final week of April where we get the introduction of these allegations of trafficking. And hey, if you don't pay us, we're going to file this complaint. Here's a draft of it, and it's going to allege these things. We don't have that when this initial demand for money was being made the preceding month. And Blackburn's skipping over that. Skipping over it and saying that the statements at issue arose directly in response to serious allegations of trafficking. No, this came in mid-step after you upped the ante. So it goes on. It says Dixon's complaint filed in good faith. That's a nice little insert there. Just let the court know. Includes well-supported RICO and TVPA claims, which are now pending in this very district before this very court. Plaintiff's attempt to retaliate against that filing by rebranding it as defamation and IIED should not be entertained by this court. The complaint must be dismissed with prejudice. Legal standards. Under Federal Rule of Civil Procedure 12b-6, a complaint must be dismissed if it fails to state a claim upon which relief can be granted. To survive dismissal, a plaintiff must plead a plausible set of facts sufficient to raise a right to relief above the speculative level. A pleading that merely offers labels and conclusions or a formulaic recitation of the elements of a cause of action will not do. Nor is it enough for a plaintiff to allege facts that are merely consistent with liability. The facts alleged must nudge a claim across the line from conceivable to plausible. Federal Rules of Civil Procedure 882 requires a short and plain statement of the claim showing that the pleader is entitled to relief. This rule demands clarity and coherence. Complaints that are vague, sprawling, or filled with speculative assertions do not provide fair notice to the defendant and violate Rule 8. Speaking of vague filings, speculative assertions, something that he got yelled at for, Tyrone Blackburn got yelled at for, do not provide fair notice to the defendant and violate Rule 8. But we had specific screenshots of the examples, right? These are the Instagram posts. These are the posts on Threads. This is an Instagram story. This is what was contained in the caption and the image or the video. Here's the text of it. So that's not really vague. That's not vague. That's saying exactly what we're taking issue with. And guys, there's a good chance that this is pulled from a template, right? Oh, I have to write a motion to dismiss, and here's a template we have, and just swap out what you need. But here it's like we're not making the case law match what we're asking a motion to dismiss to happen on. Federal Rule of Civil Procedure 9b requires that in alleging fraud or mistake, a party must state with particularity circumstances constituting fraud or mistake. Although conditions of mind, such as malice or intent, may be averred generally, the underlying circumstances must be alleged with specificity. I mean, we have these exact screenshots. It's very specific. It's the words. It's pictures of the words. Courts in this circuit have applied Rule 9b, not only to formal fraud claims, but to claims that are sound in fraud, including those based on allegations of deceit, extortion, or fabricated pretext. As explained below, plaintiff's claim fails under all three rules. His complaint lacks plausibility under Rule 12b6, fails to provide a coherent or concise narrative under Rule 8a, and fails to allege with particularity the factual basis for accusations of extortion, malice, or deception under Rule 9b. So, I mean, argument. Argument 1. The defamation claim should be dismissed under Rule 12b6. To state a claim for defamation under New York law, a plaintiff must allege a false statement of fact, 2, published to a third party without privilege or authorization, 3, with the requisite level of fault, and 4, that causes harm unless the statement is defamatory per se, in which case harm is presumed. Where the plaintiff is a public figure, the requisite level of fault is actual malice, meaning the plaintiff must ultimately prove the statement was made with knowledge of its falsity or with reckless disregard for the truth. Moreover, a public figure must plead sufficient facts to make it at least plausible that this demanding standard could be met. And remember, we had that fact that, and it was something that Dixon should be aware of for the defamation. The defamation cause of action is only against Dixon. The Dixon was making posts in relation to this Wisconsin incident where somebody made a complaint of sexual assault taking place, and headlines had Fat Joe concert in the title. But the complaint, according to Cartagena, according to Fat Joe, the complaining witness made the complaint to police about Dixon. Dixon was the one that engaged in the act. So by default, Dixon would have knowledge. Dixon would have the knowledge beforehand, before he would represent that headline, and then go on further than the headline to say Fat Joe did sexually assault somebody in Wisconsin. You had firsthand knowledge of that. So by default, if it's false and you're saying it, you would know of its falsity because you're the one with the firsthand knowledge. And this was in the complaint, so I don't see this argument working. Plaintiff Cartagena is unquestionably a public figure. He is described in his complaint and in the press as a famous rapper since the 1990s and a legend, in quotes, in his genre. Thus, to avoid dismissal, he must have alleged facts that, if true, would allow a reasonable inference that defendants made the challenge statements with actual malice. That is a really high standard, you guys. I'm not trying to minimize this standard, but what my gripe here is, they haven't alleged it. They haven't alleged it. They're ignoring he's a public figure. No, they've said it. He made the statements knowing they were false. So this argument doesn't seem to apply. It's like we're talking about a different pleading. As shown below, he has not done so. Additionally, many of the statements at issue are not actionable as defamation because they are protected opinions, rhetorical hyperbole. I hope Tasha K covers this. They are protected opinions, rhetorical hyperbole, or otherwise not plausible assertions of fact. Finally, the complaint fails to adequately plead the element of falsity with the required specificity and plausibility. Any one of these defects warrants dismissal of the defamation count. Together, they leave the claim utterly deficient. Argument A, plaintiff's defamation claim fails as a matter of law. So plaintiff fails to plead actual malice, which is required because he's a public figure. Let's see. Yep, so they're going to say, I don't want this stream to go extremely long, but they're saying here, there's no doubt he's a public figure. I don't think Tacopina and company are disputing that. But the issue, according to Blackburn, is that rather than allege any concrete facts showing that defendant knew the statements were false or entertained serious doubts as to their truth, plaintiff relies exclusively on vague, conclusory assertions that the statements were fabricated, malicious, and part of a broader extortion scheme. These allegations are devoid of specific factual support. For example, the complaint fails to identify any contemporaneous communication, contemporaneous, but they did identify the issue with the Wisconsin article that Dixon went back and was posting screenshots of headlines for, or other material that would plausibly suggest that defendants knew the statements were false at the time of publication. There is no reference to any witness recantations, discredited sources, or admissions by defendants. Plaintiff does not even allege that he informed defendants before publication that the statements were false. Such boilerplate accusations are patently insufficient. Courts in this circuit and across the country, wouldn't it be crazy if he cites himself? Across the country have repeatedly made clear that a public figure must allege more than mere disagreement or reputational harm. He must present well-pleaded, fact-specific allegations that demonstrate a plausible inference of actual malice. And they cite Bureau v. Condé Nast, affirming dismissal because the plaintiff failed to plead sufficient facts to give rise to a plausible inference of actual malice. Actual malice, this is all just the legal stuff, you guys. Actual malice is a subjective standard requiring proof that a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. I mean, we left some of this out in some of the argument above. Reckless disregard of the truth is a term of art requiring sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of this publication, and yet published with such doubts. Let's see. The Supreme Court has further cautioned that actual malice should not be confused with the concept of malice as an evil intent or a motive arising from spite or ill will. The governing standard focuses not on the defendant's attitude towards plaintiff, but rather on the defendant's attitude towards the truth. Because actual malice is a subjective standard, mere negligence does not suffice to prove a claim. The failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish reckless disregard. But the issue here is that at least one of the claims involves something that Dixon either undoubtedly has firsthand knowledge of, or he was claiming to have firsthand knowledge of. So the in-between of being able to research something that somebody else has claimed somewhere and verifying before you republish it isn't at play for the majority, well, maybe not the majority, but for more than one example that was given in the initial filing. Those things were sourced back to Dixon as the originator of the claim or something that he would have firsthand knowledge of. So this doesn't absolve those examples. So let's see. The Second Circuit reaffirmed these principles, holding that actual malice requires that the complaint plausibly allege that the defendant published the defamatory statements with knowledge that they were false or with reckless disregard of whether they were false or not. The court emphasized that the reckless conduct needed to show actual malice is not measured by whether a reasonably... So this is all just supporting case law, you guys. For from the Right Circuit. It's the Second Circuit. Actual malice can be shown through the defendant's own actions or statements, the dubious nature of his sources, well, the source is maybe himself, and the inherent improbability of the story, among other circumstantial evidence. This, to me, actually supports Cartagena more here. The Second Circuit has emphasized that the actual malice standard imposes a heavy burden to proof, a burden that is designed to assure to the freedoms of speech and press that breathing space essential to their fruitful exercise. Yeah, I support free speech, right? But if you're claiming that this Wisconsin incident, Fat Joe was accused of sexual assault, knowing that you were the one that had a complaint against you, and it just happened to be a Fat Joe concert, that's not really what free speech protects, my guy. So here, and I see Tat Clouds and FFS have entered the chat. Good to see you guys. Boops to you both. Good boops. Let's see. Yeah, we know he's a public figure. In reality, the record before this court demonstrates the opposite. Defendant Dixon's statements were not random attacks, but rather were direct responses to a documented and serious dispute memorialized in Dixon v. Cartagena. A civil... No! What? This RICO didn't even... The 2023 tweets? How were his 2023 and 2024 screenshots on Instagram, not tweets? How are those direct responses to what's being memorialized in the Dixon case as a civil RICO and TVPA filed on June 19th, 2025? Because we've also seen him argue previously that these screenshots, this content that Cartagena included in this defamation and intentional infliction of emotional distress suit, were substantially different transactions than what's going on in this Dixon versus Cartagena case. It's different stuff. So the cases should stay separate, and the second case should be allowed to continue. This contradicts what he's arguing in the letter in opposition to Cartagena's motion to stay and or dismiss and or consider the cases related. Now he's saying that it's separate. That these texts were actually about the civil RICO. The texts and the civil RICO were all about the same dispute. You argued they were distinct in your letter. Which one is it? In that lawsuit, Dixon details a 16-year pattern of financial coercion, forced labor, and sexual manipulation perpetrated by plaintiff and his enterprise. The complaint includes corroborated witness accounts, financial evidence, audio recordings, and extensive factual detail. These allegations were not only made under penalty of perjury, but were first introduced in pre-litigation negotiations with the plaintiff's counsel, protected by the litigation privilege. Now, you notice what he's not saying. He's saying it was introduced in pre-litigation negotiations, but we're talking about messages at least stemming back to 2023. But this correspondence with Blackburn and attorneys for Fat Joe wasn't happening until end of February, March. And then we don't even get the mention of RICO until the final days of this April 4-day deadline. So he's glossing over all of that. That these allegations were not only made under penalty of perjury, these allegations of forced labor, sexual manipulation, perpetrated by plaintiff and his enterprise, so RICO claim. These allegations were not only made under penalty of perjury, but were first introduced in pre-litigation negotiations and are protected by the litigation privilege. Sure, maybe you can argue that for that 2-day window, but he's making this argument in relation to, all of this defamation stuff, all of these tweets and Instagram posts in 2023 and 2024. He's blurring the line here to make an argument. So thus, Even if plaintiff could somehow survive the privilege barrier, parentheses, he cannot, the public record fatally undermines any plausible inference of actual malice. Dixon's parallel litigation establishes that he held a genuine, subjectively honest belief in the truth of his assertions, negating the reckless disregard component of the Sullivan standard. Courts have routinely dismissed defamation claims under these circumstances, particularly where the speaker's statement reflects the same content presented in judicial filings, backed by documentation and firsthand observation. He cites a case here saying dismissing a public figure's claim where defendant's statements were supported by substantial sourcing and grounded in prior investigations. Where are the other investigations? Even if ultimately unproven. We apparently have, and I'll wait to see how that plays out, but there's an allegation here that Tyrone Blackburn has made the representation that he didn't even watch the video he claimed to have of what Dixon was alleging Fat Joe and his enterprise engaged in. So we already have reason to suspect, and it's included in the first lawsuit, that the attorney didn't do the investigation on the merits of the claims. In short, plaintiff's allegations fall woefully short of what is required to plead actual malice. The court is not required to credit bare assertions of malicious intent where the complaint fails to allege any supporting facts. The plaintiff cannot transform reputational embarrassment into a federal cause of action by simply declaring himself defamed. The First Amendment does not permit a public figure to use defamation law as a cudgel to silence uncomfortable or accusatory speech, especially when that speech arises from protected legal advocacy and detailed factual grievance. Plaintiff's failure to plausibly allege actual malice is dispositive, and his defamation claim must be dismissed with prejudice. B, many of the alleged statements are non-actionable opinions or rhetorical hyperbole. We had some of this argument in the preceding this here, I think. And we're going to skip through some of this case law. Again, I will put all the documents in the folders that are linked in the description when I get done with the stream. Usually they'd be there before, but we only found these during the stream. Even if in Hey, Don't F with Justice, Jennifer Rochon is the judge. Let me see. Let me double check her name. If I can see where I have Pacer open still. Or Court Listener. I think I'm actually in that window. So let me open another one, double check. I think it's Jennifer Rochon. Yep, Judge Jennifer L. Rochon. But good to see you. This has been this has been a good time. And then also, hey to Jazzy T, good to see you. Even if plaintiff had sufficiently pleaded malice, which he has not, his defamation claim must still be dismissed because the challenge statements are, as a matter of settled law, non-actionable expressions of opinion, rhetorical hyperbole, or statements protected by the litigation privilege. And maybe this will apply to specific certain statements. But and we're accusing him of illegal acts on Instagram posts, so I'm not really sure we can just call that rhetorical hyperbole. Or especially if there's some of the statements were I'm not playing. So that's an implication that you're serious and not speaking rhetorically. So I don't know. But again, this argument is that some or many of the statements. So I guess some of them could fall under this argument, you guys. Let's see. They were made on Instagram. Okay, so the argument is that Instagram is a digital platform known for informal, exaggerated, and often hyperbolic discourse. Defendant Dixon's remarks were posted amid a public dispute with a former collaborator and contemporaneous with allegations he formally raised in a pending federal RICO and TVPA lawsuit. This is interesting wording because he's saying contemporaneous as if the litigation was happening. But the contemporaneous really only applies to things he's now alleging. And the first time we ever had anything related to pre-litigation for was 2 days before this April 29th filing made by Cartagena. So interesting wording there. And remember, this judge has both cases in front of her to look at, so she'll be able to see the same thing and make her own conclusions there. Courts recognize that the social media context combined with ongoing legal proceedings, but these things were not made with ongoing legal proceedings. These social media posts are from 2023 and 2024, with a few in 2025. Shapes how reasonable readers interpret such speech. New York courts have long held that expressions of opinion, as opposed to assertions of fact, are deemed privileged, and no matter how offensive, cannot be the subject of an action for defamation. As the Court of Appeals reaffirmed, however pernicious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. But there is no constitutional value in false statements of fact. Another case, a statement of opinion consisting of language that is loose, figurative, or hyperbolic and lacking a precise meaning. If you're saying you dated an underage girl named Nikki for 5 years and took, that's not loose or figurative or hyperbolic, is it? Is it lacking precision? We're going to argue it's not actionable here. Courts must look to the broader communicative setting to determine how a reasonable reader would construe a statement. Rather, how would you construe a statement of someone saying Fat Joe dated someone underage? They started dating when she was underage. He dated her for 5 years. Her name was Nikki. How would someone a reasonable reader interpret that? Oh, you're just joking. It's all made up. It's rhetorical. It's rhetorically speaking. I don't know how we get there. Hey to Valinda. Good to see you. Oh my goodness. Sabata, so what are your initial thoughts on this? Does Ty's presence instantly push you one way? Not really in other situations. I mean, there's been other cases that I looked at and, I read what was presented without even knowing the attorney's name behind it. But here, seeing that he's actually a named party is, square in my line of sight, right? So, and I'm not liking the arguments that I'm seeing. Like, half the time we're getting an argument that contradicts something he filed on the same day. The letter that we read earlier in the stream was also filed on June 23rd. And there's arguments there that contradict arguments being made here. So it just to me, it adds to what judges have said about Tyrone Blackburn and the way he proceeds to file litigation. It's to seek headlines. It's to get the exposure. It's vague. Things that attorneys shouldn't be doing, he's doing, or things that attorneys should know better than to do, he seemingly doesn't know better. So I don't think that this is kind of like confirming what I read over the weekend that judges have said about Tyrone Blackburn, and it's not helpful. It is not helpful. But here, he's a named party. So I think this is different than when he's just been an attorney for somebody. Here we have another attorney saying, you are engaging in intentional infliction of emotional distress by trying to threaten litigation if we don't give you money, if my client doesn't give you money. So, but again, we'll see. We'll see. You never know. You never know what we'll see what this judge does. A lot more case law, you guys. In this case, references to plaintiff as a, quote, pedophile, accusations that he was, quote, dating a minor, or suggestions that he, quote, took advantage of underage girls, falls within the realm of fiery rhetoric. These comments, while offensive, are plainly subjective moral condemnations made in the course of public controversy. No, that's a pretty specific act. It's one thing to say somebody's creepy, or you think they behave inappropriately in certain settings with someone of a particular age. But it's another to say he is a pedophile. It's another to say he dated a minor. It's another to say he took advantage of. And you can't walk away now and say, well, when I said took advantage of, I just meant I wanted to promote my show and get crowds to come out. So, maybe I was over the top in the way I invited them out. And I didn't mean the word take advantage to imply sexual activity. But we have this litigation now where that's exactly what's being asserted, that it was, he took sexual advantage of underage girls. So we can't walk this one back now because we have litigation honing out the claim with further precision. But they're saying they lack specificity, factual verifiability. I mean, this is funny, and objective grounding necessary to render them actionable as false statements of fact. Notice we don't have the quote about Nikki, a girl named Nikki that we dated for 5 years here, as an example. The Supreme Court's holding in Greenbelt, which protected the word blackmail as non-defamatory in the context of public discourse, applies with equal force here. We'll see. I think this would be an interesting legal thing to see the judge decide, but Moreover, plaintiff's claims are further undermined by the absolute litigation privilege. Many of the statements plaintiff challenges closely track or explicitly reference allegations made in Dixon's federal complaint. His June 19th, 2025 complaint, even though these social media posts are from years ago. Under New York law, statements made by parties, attorneys, and witnesses in the course of judicial or quasi-judicial proceedings are absolutely privileged if, by any view or under any circumstances, they are pertinent to the litigation. Well, it only became pertinent 2 days before this April 29th suit. I want to see how this goes. Yeah, to hold otherwise would impermissibly chill the exercise of First Amendment rights and the pursuit of judicial remedies. Chilling effect versus the impact of calling someone a pedophile. A defendant cannot be subjected to liability merely for echoing in a public forum the substance of allegations raised in a legitimate legal filing. That principle protects both advocacy and expressive freedom, especially in matters of public interest involving high-profile figures. Let's see. Accordingly, even if plaintiff had adequately pled falsity and actual malice, which he has not, he did. What? The defamation claim would still fail because the statements at issue are non-actionable as a matter of law under both constitutional and New York defamation standards. Am I missing this for real? Like, I swear we read this and we keep having Tyrone Blackburn say that he didn't plead falsity and actual malice. We got there. He said he knew they were false when he said them. But we'll see. C. Statements made in anticipation of litigation are protected by absolute or qualified privilege. We've kind of argued this already. So we're blurring the arguments again. Let's see. Let's get right. We'll skip the case law. Let's get right to what's relevant to this case. All right. So we're finishing off with if a complainant were to be subject to a liable action by the accused attorney, the effect in many instances might well be to deter the filing of legitimate charges. That rationale applies with equal force here. The challenge statements were issued by counsel in the context of active and imminent litigation and relate directly to the factual basis of the claims now before the court. They are not extrajudicial attacks or public smears. They are litigation-directed communications that fall squarely within the bounds of protected speech, with a 2-year gap. That wasn't even, with claims that weren't even part of the pre-litigation conversations until the second to last day. Accordingly, plaintiff's defamation claim is barred in its entirety by the doctrines of absolute privilege, or at minimum, qualified privilege must be dismissed. D. Plaintiff fails to allege falsity with the requisite plausibility. Even if plaintiff's defamation claim were viable, which it's not, his claim for intentional infliction of emotional distress must also be dismissed. Under New York law, the elements of IAED claims are, well, we went through this, but extreme and outrageous conduct, intent to cause or disregard of a substantial probability of causing severe emotional distress, a causal connection between the conduct and injury, and severe emotional distress. Let's see, we get a bunch of case law. Here, plaintiff fails to plead any facts that approach this demanding threshold. He alleges no physical confrontation, no sustained pattern of harassment, and no conduct that remotely approximates the level of outrageousness required under New York law. I mean, let's read this then. Maybe let's go back and read the case law. It's got to be rigorous and difficult to satisfy. The alleged conduct must be so outrageous and extreme as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized society. I mean, and he's jumping here with an argument that there's no physical confrontation, no sustained pattern of harassment. And I would disagree with that because we had a whole timeline of, March of 2023, May of 2023, texting people when Instagram wasn't getting a response. But physical confrontation isn't a requirement by this definition that we're citing above. And no conduct that remotely approximates the level of outrageousness required under New York law. The statements he complains of were posted in the context of a public dispute using expressive and hyperbolic language and were drawn mainly from allegations asserted in a federal court complaint. Drawn sounds like the federal court complaint existed before the posts were made. As such, they are not only protected as opinion and litigation-related speech, but also fall far short of the kind of egregious conduct courts have found actionable under an IED theory. And personally, guys, I would love to see some type of case law that gives judges discretion to say, or backs up a judge's use of discretion to say, I get that there's litigation, but based on the timelines here, it looks like you only filed this as a way to try to cover up and protect yourself from defamation or IIED or extortion. So, moreover, plaintiff fails to allege any facts showing that he suffered severe emotional distress as a result of the statements. There is no medical documentation, no factual support for the alleged distress, and no connection plausibly drawn between the online statements and any actionable injury. I mean, I think the harm is presumed there when when if you don't do this, we're gonna start litigation against you with claims of sexual assault against minors. But we'll see this one argued. Maybe this is something that Cartagena wants to make an amended complaint and hash out a bit more. The absence of both outrageous conduct and concrete injury renders plaintiff's IED claim deficient as a matter of law. For instance, if Dixon alleged that plaintiff flew a 16-year-old girl across state lines for sexual purposes, plaintiff could rebut that with specific exculpatory facts, such as identifying his whereabouts during the alleged event, producing travel records. Yes, this would be as the case proceeds, or denying any connection to the individual at issue. Now, we'll see what they continue to write. But those social posts cited in the complaint do not give a date and time frame. So how is somebody supposed to rebut somebody's claim of something other than just by saying, that's not true, that never happened? How can they get more particular and say, you know what, let me put up a flight record and my whereabouts for every second of my entire life? This is such an unreasonable argument because they weren't given a time frame to identify to dispute this fact. Or denying any connection to the individual at issue. I mean, I feel like we had a complete denial in the pleading, but okay. This is stressful, you guys. If Dixon claimed plaintiff had sexual contact with a minor in a particular city or during a tour, plaintiff could demonstrate impossibility or providing conflicting records. This seems like a reference to Jay-Z and Busby with the Jane Doe. Yet the complaint is devoid of any such rebuttal or contextual clarification. Rather than refute specific factual claims, plaintiff adopts a litigation strategy grounded in general denials and rhetorical indignation, which cannot meet the burden imposed by rhetorical pleading standards. This is contradictory to the preceding argument in this filing that my client was just making rhetorical or vague opinion statements. Now you're arguing that we should dismiss Cartagena's complaints because he had the opportunity to magically, with specificity, counter the claims being made, as if the claims being made against him contain the specific context. So which one is it? Were your client, Terrance Dixon's posts, were they specific, or were they just rhetorical opinions and nothing specific that could be, factually verified? Because this implication, the implication of what's being argued here, contradicts what we're arguing previously in B. Was it B? Yeah, B. This contradicts what we're arguing in B. But okay. Moreover, and again, he's not addressing specific screenshots one by one. He's using one example here. So I get that some arguments could apply to some examples, but this pretty much seems like a broad stroke. Sometimes everything's rhetorical, sometimes everything's specific, and Cartagena could have addressed it with specific exculpatory evidence. Moreover, to the extent the complaint seeks to attribute defamatory meaning to pre-litigation emails or settlement demands transmitted by defendant Blackburn, an attorney, such communications are... Now we're arguing that the complaint tried to attribute defamatory meaning to stuff that came from Blackburn. Blackburn wasn't named as a party in the defamation cause of action. I don't know why it matters, an attorney, I guess client privilege here. But the complaint, this never happened. The complaint wasn't saying Blackburn's communications were defamatory. Blackburn is named in the intentional infliction of emotional distress. So this is a weird argument. It says, moreover, to the extent the complaint seeks to attribute defamatory meaning to the pre-litigation emails or settlement demands transmitted by defendant Blackburn, an attorney, such communications are plainly protected by the qualified litigation privilege and are not considered defamatory publications under New York law. This wasn't argued in the complaint. Yeah, so April O'Neil's baby daddy, good to see you, says, or what if the complaining guy was the one that had the girl around him and he was around Chubby Joe? So I based on what's being represented in Cartagena's filing, the April 29th one, it seems like there's the incident, the Wisconsin incident, the complaint was actually against Terrance Dixon, which means Terrance Dixon would know that. He'd be the person to know that. So, I don't know. That one, I'm excited to see how that plays out, because we haven't really seen that addressed so far in this motion to dismiss. The claim that it was actually Terrance Dixon that the complaint was made about in relation to the Wisconsin event. So, and Don't F with Justice says, was a CRD complaint filed? I have not seen any indication of such. It looks like just a bunch of texts looking for money, credit on songs, and that escalated to now litigation related to claims of sexual assault with minors, RICO. Just a hot mess. But we've seen like vague references in here that these issues have been discussed contemporaneously, but I don't know. Let's see. Plaintiff concedes in his own complaint that many of the statements were made directly to him or his legal counsel in the context of settlement negotiations or pre-suit discussions for IIED. That is not the same as trying to seek defamatory meaning to the communications about the statements that were made in 2023 and 2024. These communications are not actionable. Indeed, to hold otherwise would expose virtually every demand letter or pre-litigation threat to potential liability and chill legitimate legal advocacy. I don't think it would chill legitimate legal advocacy. It would chill whatever is going on here, which I'm not sure is legitimate legal advocacy. That means well. That's way that I'm open to changing my mind. And even if such privilege were not absolute in this context, plaintiff fails to plead facts that would overcome it. He does not allege that the statements were irrelevant, gratuitous, or made in bad faith. Taken together, the complaint falls far short of alleging falsity with the factual heft necessary to withstand a motion to dismiss. Plaintiff's approach, asserting the falsity of explosive accusations without addressing their substance, they said it wasn't true, is both procedurally inadequate, and there wasn't much substance there, right? They were vague, is both procedurally inadequate and substantively unpersuasive. The court need not and should not discredit naked denials as sufficient to state a claim, particularly where the stakes involve speech concerning public figures and matters of substantial public concern. Accordingly, for this reason as well, the defamation claim must be dismissed. And now we're going over to the IIED claim, the plaintiff's IIED claim is duplicative of his defamation claim. It isn't really. You made representations up here as if it was. But the principle of dismissal for duplication applies here. Let's see. Plaintiffs cannot press both direct and supervisory claims against a single defendant, with both claims premised on the same conduct. The conduct for the IIED is the introduction, if you don't give us a sum of money, this is our demand letter, we're going to claim this about you. We're going to start litigation. We're going to initiate litigation by filing this. There is a difference there. It's a different action. This is crazy. The courts have consistently held that when a supervisory liability claim is based on the same facts as an underlying direct claim, it is redundant and must be dismissed. Let's see. The IIED claim is barred as duplicative of the defamation claim. Under well-established New York law, a plaintiff may not bootstrap an otherwise deficient defamation claim into an intentional infliction of emotional distress claim based on the same facts. The facts are different. Courts have consistently held that where the alleged conduct forming the basis of the IIED claim is identical to the allegedly defamatory statements, the IIED claim must be dismissed as duplicative. Most recently, the First Department reaffirmed this rule in Reeves v. Associated Newspapers. They upheld that an IIED claim resting on the same core allegations as a defamation cause of action must be dismissed as a matter of law, but that's not what's happening here. The IIED is oh my gosh, I don't need to say it a third time. I think you guys get me. I think you can disagree with me, but I think you guys get what I'm saying. The same principle applies to declaratory judgment claims that merely duplicate a defamation theory under a different label. Let's see. Here, plaintiff's IIED claim is entirely derivative of his defamation allegations. He does not cite any distinct conduct. Yeah, well, that's where he brings in an entirely different party. He brings in Tyrone Blackburn and the Blackburn law firm. That's distinct conduct by different people from the alleged public statements that form the basis of his defamation claim. Indeed, the IIED claim merely recharacterizes those same statements, accusations posted on social media, and conveyed in legal correspondence. No, we have entire new ones, including conversations from like April 22nd, 23rd through the 28th as outrageous conduct. But New York courts have made clear that a plaintiff cannot circumvent the constitutional and common law limitations on defamation claims by simply relabeling them as emotional distress claims. So, nor can plaintiff rely on authorities like Fleischer and Birkenfield, which both underscore the high bar for actionable defamation or derivative emotional distress claims. In Fleischer, the court found the challenge statement to be a non-actionable opinion. And in Birkenfield, the court found that the plea allegation and allegatory defamatory statements were substantially identical, an alignment that is clearly lacking here. Wait, an alignment that's lacking? Maybe I'm reading this wrong. Maybe I'm reading that wrong. I would say an alignment that is clearly present here if that was my argument that they were substantially identical. But okay. Accordingly, plaintiff's IIED claim must be dismissed in its entirety as duplicative of his defamation cause of action and legally insufficient under controlling New York precedent. I would love And I know this would never happen, right? Because it's attorneys maybe discussing things with their client, legal strategy. I would love to be a fly on the wall of like when attorneys get notice that a response or opposition has been filed. I would love to see their face as they read through it and respond to it. Um, let's see. Plaintiff fails to allege conduct that is extreme and outrageous as required by New York law. So we've gotten into some of that. Let's see. Yeah, I feel like we've already argued this. The high threshold of IAD claims has got to be so outrageous in character. That standard is not met here. Courts routinely dismiss IAD claims arising from allegations of false accusations, legal threats, or even retaliatory workplace conduct. Wait, the example here is in Dreimer v. Zionist Org of America, the plaintiff's claim alleging anxiety in a cardiac event resulting from a pattern of harassment was still deemed legally insufficient. The court rejected an IED claim in Suarez v. Bakelchuk, where the conduct, although extremely offensive and bizarre, was not legally outrageous. Let's see. Likewise, in Flaherty v. Dixon, the court found that even where the plaintiff alleged defamatory statements that cost him employment and damaged his reputation, those actions did not meet the requisite standard for outrageousness under New York law. Well, I don't know what the claims were here, but we're expecting future damages too. Employment, brand deals. The litigation even threatens to bring in market, whatever the market something company was, as a party. So I don't know how we get around that part unless we just say it's not outrageous. The court emphasized that even if such statements are false, hurtful, or career-ending, they do not satisfy the strict legal requirements for IAD. Also, big shout out to Flesh of the Gods here, hanging out, sending us good wishes. Yeah, so check out Flesh of the Gods. He's been covering the Ronnie Walker trial. I think you've been doing that earlier in the days, right? So it's not so late at night. But the Ronnie Walker trial, you'll see FFS over there hanging out. I think Tat's been over there. So that's been an interesting one to watch. And going through the witnesses quickly in that trial. I always love to see a trial where the witnesses move along. Because it's just so not what we're used to after a million days in the YSL trial. And a little bit with Karen Reed. Let's see. Indeed, the conduct plaintiff describes here, posts on Instagram and alleged threats of litigation are routine in contentious public disputes, particularly where, as here, defendant Dixon has already filed a civil complaint. Already, as in 19th. The 19th of this month, filed a civil complaint asserting RICO and TVPA claims against plaintiff. Courts have consistently held that such conduct, even if emotionally distressing, is not actionable under the exacting standards of New York tort law. Let's see. In short, the statements and conduct alleged by plaintiff, public criticisms, social media accusations, and pre-litigation threats are paradigmatic examples of conduct that courts have repeatedly deemed insufficient to sustain an IED claim. As such, this cause of action must be dismissed as a matter of law. So really we're really only addressing, I mean, do we address the law firm? I mean, are we addressing why? Because again, the second cause of action, this IIED, is against Dixon, Blackburn, and the law firm. I don't really know if we've addressed. I don't know if we've addressed in this section why, if we do not find that it's covered by privilege or whatever, that it also would not meet the standards of something outrageous. We just kind of skipped addressing that for the other defendants, but okay. C, plaintiff fails to allege severe emotional distress. In addition to alleging extreme and outrageous conduct, a viable IAED claim must plead severe and debilitating emotional distress, not merely anger, indignation, or generalized reputational harm. So, but when we talk about generalized reputational harm and something's inherently damaging, You're claiming someone's a pedophile that dated a 15-year-old girl or whatever. And we're kind of getting out of this or. A plaintiff must allege that the distress suffered was so serious that no reasonable person could be expected to endure it. I wouldn't want to endure being accused of being a pedophile. Courts consistently reject IAD claims where the alleged emotional harm is vague, conclusory, or entirely derivative of reputational injuries. And again, I do think that this is an area where maybe we'll see an amendment to the complaint to hash out further, more of the emotional damages. But I think they want to be careful with that, because if you allege certain things, like if you start saying, I have PTSD from the claims, now, well, we need you to substantiate your claim of having something that's diagnosable. So let's get your medical records, your therapy records. There's a discovery line that you don't want to cross either. And maybe Tyrone Blackburn wants to goad Fat Joe into going there. Moreover, as a public figure, plaintiff must meet the heightened burden of pleading actual malice with particularity. That is, he must allege facts showing that defendants either knew their statements were false or acted with reckless disregard for their truth. We've talked about this already. Let's see. A qualified privilege, such as the litigation privilege or the fair comment privilege, may only be overcome by showing of either actual malice or common law malice. To show actual malice, plaintiff must prove the defendants either knew the statements were false or published them while harboring serious doubts to their truth. And again, we have claims that Dixon would have first-person knowledge of. So, and also as far as an attorney who had a duty to investigate, saying that they didn't actually look at the video that they used in pre-litigation communications to say, we have a video that shows you doing this. Oh, well, what do you mean? Let's see the video. I didn't actually watch it. We have an issue here with representations made by Blackburn as well. That I don't think just simply saying the plaintiff didn't allege anything with specificity, that's a pretty specific example. Reckless disregard is not simply a failure to investigate. It requires a high degree of awareness of probable falsity. Although actual malice is a subjective inquiry, courts may infer it from objective facts. Well, I think that might be a fact at dispute whether or not Tyrone Blackburn said that, right? Did he actually say, oh, I didn't actually watch that video? But if at this stage, if the judge assumes that that allegation is true for the sake of this stage, then I think we've passed this bar. By contrast, common law malice focuses on the speaker's attitude towards the plaintiff rather than the truth of the statement. It requires proof that the defendant was motivated solely by spite or ill will. As the Second Circuit explained in Konikoff v. Prudential Insurance, the critical difference between the two forms of malice is that actual malice targets truthfulness, while common law malice targets the speaker's animus towards the plaintiff. Here, plaintiff offers no factual allegations beyond conclusory invocations of malice. I don't know, are we misrepresenting what factual allegations means? And I say this, like, oftentimes when a celebrity has a major lawsuit against them or they're filing one, a lot of people get introduced to their interest in like law news, legal news, because of a celebrity story, and they have to learn as they go. Like this stuff, if you don't know what things mean, you got to look it up. There's a lot to digest. And one of the things I see often is people will read a complaint, a lawsuit that's filed. The initial thing that opens a case and that header that says factual allegations, people will take quotes from the factual allegations and assume factual to mean it's been proven. It already has been proven and hashed out. The court has found that this was proven, but it's at that stage, it's just an allegation of facts. Even when it's a statement of facts, these are the statements of the facts that I'm alleging when I'm bringing this suit against somebody else. But in common language, it's incorrectly interpreted to mean everything that follows is a proven fact, when really it's the facts that are likely going to be at dispute until, the case plays out. So, but here it seems like we're being wishy-washy with what factual allegations mean. He's saying plaintiff offers no factual allegations. There were allegations. We have this language beyond conclusory invocations of malice. This seems like the argument is it's not a proven fact, so that's not enough. And that's just an incorrect argument to make. That would plausibly support either standard. There are no well-pled, and now we're going to well-pled facts, showing that defendants entertained serious doubts about the veracity of their statements, nor are there allegations establishing that defendant acted solely out of spite. Indeed, the challenge statements arise in connection with sworn legal proceedings and personal experiences recounted in connection with a broader pattern of alleged misconduct. Without more, plaintiff fails to meet either the constitutional or common law thresholds required to overcome privilege or sustain an IAD claim. Plaintiff's complaint is silent on this requirement. He does not claim to have suffered psychological breakdowns, sought mental health treatment, been diagnosed with the condition, or experienced any lasting functional impairment. Instead, he vaguely alleges that the statements cause emotional distress. And again, I think we could amend this and add more in. And maybe Blackburn wants that because he wants to be able to challenge specific claims, such as, some type of diagnosis. In sum, plaintiff's IAD claim is both procedurally barred as duplicative and substantively deficient under the controlling case law. It should be dismissed with prejudice. And then argument 3. The complaint should be dismissed under Rule 8 and 9b for failure to plead with sufficient clarity and particularity. So, a bunch of case law here. It's required that a complaint contains a short and plain statement of the claim, showing that the pleader is entitled to relief. Rule 8 is violated when a complaint is vague, conclusory, or so disorganized that it fails to provide defendants with fair notice of the claims. I thought it was pretty specific. I don't think it was disorganized. I don't really think it was necessarily conclusory of what specific was being presented. Although there were conclusions that, my client never did these things, therefore this is false. The specific statement is false. So we'll see. We'll see. The complaint here fails to clearly identify which statements are alleged to be false, why they are false, and how each defendant individually is liable. The allegations are riddled with vague references to, quote, harassment, malicious intent, and defamatory conduct without linking such phrases to actual verifiable events. How many dates with timestamps did we see in the complaint, you guys? Oh my goodness. Oh my goodness. And also, thank you so much, Flesh of the Gods, gifting a membership. I'm looking over here for insights from the chat and I see some awesome green. So big thank you, Flesh of the Gods, supporting the channel, making some green out there. This is just I don't know. Maybe I'm misreading. Maybe I imagined that we had timestamps and specific days, dates, the time someone emailed me, the day someone called me, what they did before and after that correspondence, what the next correspondence was. That's not vague. That's a timeline. Finally, beyond the substantive deficiencies of each cause of action, the complaint as a whole should be dismissed for failing to comply with fundamental pleading rules. Rule 8 requires a short, plain, and plausible statement of the claim. Oh, so you mean 20-something pages instead of 158. As discussed above, plaintiff's pleading is anything but short or plain. It is a sprawling narrative that drags... Why are we mentioning other suits? It is a sprawling narrative that drags in the extraneous matter. For example, references to other lawsuits and third parties like Desiree Perez and Rock Nation in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. These side allegations do not belong in a well-pleaded complaint and highlight... Did I miss that? Did he call out that specific lawsuit in the... Hold on now. This is the Joe Taka. Is he getting confused? Because what we're reading is a motion to dismiss this April 29th complaint. And I can search this document. Like, I'll search for Cartagena. That's coming up. I don't see Desiree. I don't see Perez. Let's do nation instead of rock, because maybe I don't see. I have National League. I don't see nation. We just have National League. I don't have ROC. I don't have ROC. Are we lost? Are we lost, chat? Oh my goodness. I'm actually lost. I don't know which tab I was in. Let me find our way back. Is it this? Okay, I think it's not loading anymore. I might have, let me reopen it. There we go. Okay. Am I lost? As discussed above, plaintiff's pleading. Plaintiff here, this is the April 29th, is anything but short or plain. It is a sprawling narrative that drags in the extraneous matter. For example, references to other lawsuits and third parties like Desiree Perez and Rock Nation. These are in quotes, in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. Was there, I mean, this has all been about the complaint. We haven't heard an amended complaint. Okay, hold on. Is there an amended complaint? There's more, guys. Let's see. Well, this is just the order. Let's see if there's anything else attached here. Order. We don't want that one. And then this would be the complaint. Okay. We'll download this. It says 25 pages, so I don't think it's that much longer. Let's see. And hold on, let me get this in Google Drive so we can open it on stream. Let me rename it. So if you guys want to go and look at this, FAC for First Amended Complaint. So let's see. Where do we get this? Okay, it's searchable, but I'm not getting Desiree. I'm not getting Perez. Unless I downloaded the wrong one. No, filed May 1st. Is there... I don't see a mention of the word conspiracy. Let's try nation. We just have the National League. Is there anything else on anything else? Amended complaint. Oh, and the order says to allege the citizenship of each constituent. This is number 14. So even this service in May was that amended filing where we don't see a mention of Desiree. Where is this reference coming from, you guys? This is a little weird. I don't know what to make of that because I don't see what they're referencing, but it's being referenced in quotes here, so I don't know. So back to here. Plaintiff's pleading is anything but short or plain. It's a sprawling narrative that drags in the extraneous matter, for example, references to other lawsuits and third parties like Desiree Perez and Roc Nation, in an apparent attempt to suggest a conspiracy without any coherent factual link to the case at bar. These side allegations do not belong in a well-pleaded complaint and highlight its implausible speculative nature. The inclusion of such material tends to confirm that the plaintiff is using this lawsuit to fight a broader battle or agenda rather than resolve a concrete legal inquiry. That is improper under Rule 8, which is designed to focus the litigation on specific actionable events. When one strips away the colorful but irrelevant commentary, one is left with a relatively simple dispute. Dixon made accusations, plaintiff says they are false. That could have been pleaded in a few paragraphs. Instead, we have a convoluted pleading that obscures the core facts and forces defendants and the court to sift the wheat from the chaff. Dismissal is warranted on this ground alone, with leave, perhaps, to replead in a coherent fashion. Although in this case, repleading would not cure the substantive problems identified in sections 1 and 2. So dismissal with prejudice is appropriate. And guys, before we move on to the next paragraph, I'm going to say I don't know what this is talking about. I don't know if there's another pleading that we're not seeing. And because they're referring to it as a pleading and the complaint, and plaintiff complaint, that means Cartagena's complaint. I don't know, maybe it's in the other lawsuit, but that wouldn't be the complaint. This is a motion to dismiss the complaint in Cartagena v. Dixon. So if you're raising an issue and saying it should be dismissed because of a failure to comply with rules for the pleading, it would have to be applicable to the complaint made here in this case. I think they're just confused. I don't know. Oh my gosh. I didn't mean to sit here stomped on stream, you guys. I was just trying to figure it out, but I don't know what to make of that. I don't know what to make of that. Additionally, as noted, and yeah, I'm so confused. And it's one of those things where Desiree and Roc Nation, their names are being brought up in a bunch of cases. So I feel like, maybe I was missing a reference and I just overlooked it, but I just don't see it in the complaint at issue here or the amended complaint, which was apparently only updated to fix a jurisdiction issue for the law firm as a party. So additionally, as noted, and dismissal with prejudice is noted. So additionally, as noted, Rule 9b's particularity requirement applies to any allegations of fraudulent misrepresentation or deceit in the complaint. Plaintiff insinuates that defendants engage in a form of extortionate fraud, essentially that they fabricated heinous allegations to extort money from him. While plaintiff has not labeled a count fraud, this allegation pervades his narrative and even underpins the claim of malice. Such allegations must be pleaded with particularity. Here, plaintiff fails to identify with specificity any misrepresentation beyond the defamatory statements themselves, which we've addressed. If plaintiff means to allege that defendants falsely represented an intention to sue without actually planning to, or falsely representing that they had evidence when they did not, those are species of fraudulent inducement or false pretenses that require detail. Well, we had the specifics about the video that Tyrone Blackburn apparently represented that he had and would make public. And then, I haven't actually watched the video. That's pretty specific. And if you don't know which one we're talking about, then you either need to say that specific allegation in the complaint is meritless and untrue. You need to address that specifically. Or you don't know what video they're talking about, and that seems more like a you problem than a initial pleading problem. So, and I don't know, it's also weird to volunteer if plaintiff means to allege that defendants falsely represented an intention to sue without actually planning to. This kind of, I read between the lines, maybe this is why we're actually suing. Because remember, when you gave that 4-day window, you were suddenly sending a bunch of emails. Are you going to accept our demands yet? Are you going to accept our demands yet? Oh, you know what? Today's the final day. We're going to make it even worse. If you don't do it right now, we're going to also throw in RICO and TVPA claims. That kind of, this worry, you're volunteering this, right? You don't need to actually address this because this wasn't explicitly alleged of Tyrone Blackburn. But volunteering this makes it seem like maybe that is why we ended up with this June 19th complaint. So, not this. That's not what we're reading right now. This is the motion to dismiss, but I don't know. Yeah. Oh, and I think For Always Forever for Life is a bit behind because she says, yes, people will assume that it's been proven. It's like, I don't like to get annoyed when I see that because I understand why people would think that. So I just like to give everyone the grace, you know, hey, that's, in the legal context, when you see a statement of facts, it doesn't mean stuff that's proven it's beyond contest. You can't contest it anymore. Right. But when you have someone that's new, interested in the story, and they're reading stuff for the first time, I get why they take it that way. But it can be problematic because then a bunch of people are saying, well, it's been proven that, and that's really not what happened, but dozens, hundreds of people start thinking that. And because so many people are saying it, an outsider that didn't look at the document themselves or, be familiar with legal terms, they might say, well, so many people are saying it's true. And that's how we get this kind of like chaotic, uncontrollable reaction that leads to misinformation and misinterpretations on a broad scale. So, but when you catch up to us, hey, to pass For Always Forever for Life. Let's see. So they say, let's see, plaintiff fails to identify with specificity any misrepresentation beyond the defamatory statements. If plaintiff means to allege that the defendants falsely represented an intention to sue without actually planning to, or falsely represented that they had evidence when they did not, those are species of fraudulent inducement of false pretenses that require detail. None is provided. Thus, to whatever extent plaintiff's claims rely on a fraudulent demand theory, they should be dismissed under Rule 9b. Moreover, as the Second Circuit explained in Bureau v. Nest, even though Rule 9b allows malice to be alleged generally, that does not save a public figure plaintiff from the obligation to plead a plausible factual basis for malice under Rule 8. What header are we under? It should be dismissed under Rules 8 and 9b for failure to plead with sufficient clarity and particularity. Let's see. This seems like a slightly different argument. Yeah, we're arguing 9b, which is included in the header. But although malice can be alleged generally, that does not save a public figure plaintiff from the obligation to plead a plausible factual basis for malice under Rule 8. The plaintiff's attempt to generally aver malice without facts fails, as discussed. In short, the pleading does not pass muster under Rule 8 or Rule 9b. Well, you kind of argued that it would under 9b, but you're saying it doesn't under 8. And now you're saying it's either. But I think, again, maybe amend it to get more specific. In sum, this complaint is an archetype of the kind of case that warrants dismissal at the threshold. It is legally insufficient in multiple independent respects and appears to be fueled by ulterior motives rather than a genuine belief in a viable claim, allowing it to proceed without subject defendants to costly discovery and protracted litigation over what is, at its heart, an interpersonal feud and smear campaign, the sort of dispute that our courts vigilantly guard against turning into a federal case absent compelling circumstances. No such circumstances are present here. Is there something where a smear campaign is different than defamation? Let's see. Is there like a legal? Is there? I mean, we don't have case law here saying that a smear is not the same as defamation. Um, I don't know. This seems like this doesn't make sense to me. No such circumstances are present here, as this very court has emphasized. You know what else this court has emphasized about Tyrone Blackburn? Anyway, allegations of fraud or malice must be supported by concrete facts, not by conclusory assertions or narrative framing. In Hillbit, the court denied the defendant's motion to dismiss an anti-slap-based claim where the defendant's defamation lawsuit was dismissed due to their failure to plausibly allege actual malice beyond conclusory speculation. The same deficiency applies here. Plaintiff's failure to plead falsity, intent, and personal knowledge of wrongdoing. He did plead personal knowledge. I think we've pled falsity, I think we've pled intent, and I think we've pled personal knowledge. And it's a issue of fact, I guess, not a deficient pleading, but that's my read. Again, I'm not the judge. Renders the complaint deficient under Rules 8 and 9b and warrants dismissal on those grounds alone. And then the complaint is barred by anti-slap. So let's see. Here, plaintiff is a Grammy-nominated celebrity alleging reputational harm from public statements made in connection with litigation and public allegations of sexual abuse, labor exploitation, and trafficking. These are matters of indisputable public interest. The statements at issue were made by a former longtime associate, defendant Dixon. Are you going to say that he would have personal knowledge? I don't think we should argue that. On Instagram and in legal filings, which constitute public forums. Let's see, Abitbol v. Rice, social media qualifies as a public forum. A speech regarding public figures and alleged abuse falls within the statute. Further, the speech was made in connection with a civil RICO and TVPA lawsuit. In connection with a 2023 post in connection with a 2025 filing, which itself alleged systemic abuse and forced labor. Under settled law, speech related to legal proceedings and matters of social consequence constitutes protected speech. Definity found versus New York Times, affirming dismissal under anti-slap law, where speech was part of a robust public debate on a matter of political, legal, and scientific importance. Now, we're getting a lot of New York Times cases cited here, but what's the difference? If New York Times is reporting on something, probably relying on information that they investigated through somebody else. But here, we're relying on things where the source of the accusation regarding situations where there would be firsthand knowledge from the person making the statements. There is no reporter in between that's relying on the word of somebody else. For Dixon, for the defamation, he's alleged things that he had firsthand knowledge of, that he says he had firsthand knowledge of, or reasonably would have had firsthand knowledge of. And for the IED, we have the attorney, the law firm, representing that we verified these things, and perhaps they didn't. So I don't think that's the same as the New York Times maybe investigating something but not enough, but they're relying on somebody else's word. And that is a very high bar to get around. I think there's a lot of protections there for these publications. But it's very distinct. It's very distinct from someone with firsthand knowledge. I was there, I witnessed it, I saw it. I know. Because I've been around him so long, I know. That's very different than a reporter reporting on something. So I don't know how this case compares, but okay. Plaintiff, as a public figure, cannot escape the requirement of alleging and ultimately proving actual malice by clear and convincing evidence. He has failed to do so. As explained above, the complaint is devoid of non-conclusory factual allegations, showing that defendants knew the challenged statements were false or recklessly disregarded their truth. At most, plaintiff claims the allegations were false and damaging. But that is not enough under New York Times v. Sullivan and his progeny. So moreover, the case of Hillbit and Cassava reinforces this point. There, this very court dismissed defamation and fraud claims because the plaintiff failed to link any specific falsehood to any identified defendant. I don't think that's relevant here. And again, this is an issue that Tyrone Blackburn has had with his own filings, or he's not linking the action being accused, maybe not falsehoods, but the actions in general, to a specific defendant, a named defendant, or to plausibly allege actual malice beyond conclusory speculation. The same reasoning applies here. Plaintiff has not identified specific falsities or alleged actual malice in a non-speculative, plausible manner. Indeed, as in Halebit, the complaint's failure to isolate actionable statements from constitutionally protected opinion and legal advocacy is fatal. So, maybe the judge will find that. In light of the above and consistent with the anti-SLAPP framework adopted in this district, plaintiff's complaint must be dismissed in its entirety. Furthermore, defendants intend to seek recovery of attorney's fees and costs permitted under the Civil Rights Law 70A1A, which allows prevailing defendants in anti-SLAPP proceedings to recover mandatory costs upon dismissal. So in conclusion, for the foregoing reasons, defendants Terrance Dixon, Tyrone Blackburn, and T.A. Blackburn Law respectfully request that the court dismiss the complaint in its entirety with prejudice according to the Federal Rules of Civil Procedure 12b6, 8a, and 9b. The plaintiff's claims are facially and fatally defective. He fails to plausibly allege actual malice as required for defamation claims by a public figure. The First Amendment protects the statements at issue as a non-actionable opinion, rhetorical hyperbole, or privileged litigation-related speech. The intentional infliction of emotional distress claim is duplicative and in any event does not allege conduct remotely approaching the extreme and outrageous standard required by New York law. Furthermore, the public complaint is rife with conclusory allegations, speculative insinuations, and irrelevant material that fails to meet even the minimal pleading standards of Rules 8 and 9b. In short, this lawsuit is not a good faith invocation of the judicial process, but an attempt to chill protected speech and retaliate against Dixon's and his counsel's legitimate legal claims. Well, but I almost said Busby. Blackburn isn't making a claim. Blackburn isn't a plaintiff in the June 19th suit. So this is weird wording. But okay. Allowing this case to proceed would subvert fundamental First Amendment protections and subject the judicial system to abuse. So it's like he's trying to extend anti-SLAPP to this IAED claim against himself, just because he's arguing that it would apply to Dixon. Accordingly, the complaint should be dismissed with prejudice and such other and further relief granted to defendants as court deems just and proper. So there you go. This was June 23rd. Tyrone Blackburn. That's where we are. I think that was like the final. Yeah, so that was we're caught up on that docket. Let's see if there's anything on the other case. And the next day he hits a process server with his car. That was in May. That one was actually in May when they were attempting to serve him with whatever related to this case. Oh my goodness. Let's see. Let's do, that's not the right case. Yeah. So Dixon, let's see. The complaint. Okay, actually, this says Magistrate Judge Sarah Netburn. Oh, and I guess so this is before Judge Rochon. There is a notice of initial pretrial conference, August 1st, 9:30 a.m., you guys. So, definitely wanna look for reporting on that day. Letter motion to stay. So we looked at that. Oh, okay. Notice of appearance by Alex Spiro on behalf of Rock Nation. Notice of appearance by Joanna Elizabeth Manillo on behalf of Rock Nation. Motion to dismiss filed by Rock Nation. This is where we're getting the reference from, but it has nothing to do with the motion to dismiss Cartagena v. Dixon. Oh my goodness, you guys. So let's see. This is 32 pages, you guys. This is where, but how improper for Tyrone Blackburn. So you open another case. And notice he doesn't argue that the cases should remain distinct because of the different parties. He leaves that out. He just makes a vague argument that things are substantially different. But he files, this case was filed on June 19th. Rock Nation's a party, a named party. Rock Nation files a motion to dismiss on June 23rd. And on June 23rd, Tyrone Blackburn has already incorporated a mention of Rock Nation in his motion to dismiss Fat Joe's April 29th filing and whatever was amended on May 1st. That doesn't make sense. Like this, what's going to be alleged in this? He brought Rock Nation into this. So how is he using that as a reason to dismiss Fat Joe's claim? Oh, the plaintiff's trying to introduce a conspiracy. What are we talking about? So let's see. I mean, Desiree's not even mentioned in this. So the only mention of Desiree is perhaps in Dixon v. Cartagena. Let's see. Guys, this is a long stream, so we're not going to read this. But the only mention of conspiracy is in relation to Dixon, suggests he's also bringing related state law claims, including intentional infliction of emotional distress, assault, battery, conspiracy. That's the only mention of conspiracy in here. So where are we getting that mention in the motion to dismiss Cartagena v. Dixon? Where Blackburn's alleging that plaintiff, Fat Joe, is bringing in unnecessary references to other lawsuits and actions related to Desiree Perez and Rock Nation to argue a conspiracy, because that's not in the complaint. Maybe I'm missing something and it's not on the docket for either of these related cases. I'll get this downloaded and put this in as well. So Alex Spiro has entered the chat, you guys. So Spiro, Rock Nation, MTD, Dixon v. Nina. I'll get that in the folder as well. I don't know, you guys. I don't know what to make of this. This is stressful. This is a stressful way to litigate. That's my conclusion. Big thank you to you guys for hanging out. I mean, we were gathered here today because of this like unbelievable story. Hearing that lawyer suing Fat Joe arrested for allegedly mowing down Joe's process server. Like just a crazy way to get in here. Like what? But yeah, and this was May 12th. May 12th. Arrested today for something that happened on the night of May 12th. So don't F with justice. You know I'll be over on X with this. Flesh of the Gods. Oh my gosh, you probably have just like an archive of things that you could bring in as context to some of this stuff. So I'd be excited to see that. Guys, as far as the Dixon v. Cartagena, remember Happily Angry Lawyer did a stream looking at that complaint, the one that was filed on June 19th. If you want to go look at that. Maybe we'll do another stream to look at Rock Nation and Alex Spiro. I'm going to talk about it a little bit on X, but I'm hungry and I have no voice. So we're going to wrap this one up. Thank you for hanging out, you guys. Flesh of the Gods, do you have anything going on tonight? Let me pull up your channel. Probably more Ronnie Walker tomorrow, maybe. So I'm gonna operate under the assumption with the Ronnie Walker trial, that's what Flesh of the Gods will be doing probably tomorrow with more court streams. Or did they already do the verdict? They're done. They're done. So if you want to rewatch that, make sure you go check out Flesh of the Gods. And guys, until next time, I don't know if I'll go live for. I don't know what'll happen next. If there's any motion with Courtney Clenny or any of the other cases that we have our eye on, obviously we'll go live for that. Just look for a notification. Until then, hope you're all doing well. Have a good one, and thank you so much for hanging out. Bye, guys.